rewind. We're going to call the meeting to order August 7th. It is at 9:02. Before we get into our schedule, I did want to make mention that, make everyone aware of Dr. Ted Rokita has passed away last week. Ted was a board member here for many years, and he is also the father of our Attorney General, Todd Rokita. So on behalf of the state board, we would like to express our sincere sympathy to Attorney Todd Rokita and his family and keep them in our thoughts and prayers. So, okay, may I have a motion to adopt the agenda? And is there a second? Second with that. All righty. And the next is we have 3 sets of minutes. So let's do each one separately because I did find some typo errors and things like that. So our first set of minutes would be for February 6th. And some of the things that I noted was on page 3 under, and this goes through several pages, when it goes through participating board members, at the bottom it has, to be consistent, it has like Dr. Kevin Ward, DDS, and Dr. Darren Sheeline, DDS. So I think we need to get rid of the doctor part and then just put the initials after so that it's consistent with how everything else is written on those. So that goes through a number of pages. If you know, it's on page 4, it's on page 5, all of those. The other thing I noticed on that page was for Jordan Jameson, they have it under here as Mr. Jameson, and I was under the assumption that was a girl, because that's the one that was doing the brackets in her hair salon. So all of that under board action, it has like Mr. Jameson. So we would need to change all of those to Miss Jameson. And another thing, just for point of clarity on some of these, when it mentions the attorney, it has like Mr. Matthew. I don't know if it's more proper for us to say Attorney Matthew rather than Mr. We've always said it attorney, you know, I don't know what, I just thought that was more proper to say attorney rather than Mr. So, you know, that's on page 3. Also on page 5, it's Attorney Grable. And I think that's yeah, and then again on page 12, it says Mr. Matthew, and it should say Attorney Matthew. So those were the only corrections that I had. Did anyone else have any corrections for February? All right, would someone like to make a motion to approve? Robert, and a second? Ed, and all those in favor say aye. Aye, anyone opposed? All right. The next set is the April 10th minutes. And then again, on page 2, under participating board members, it says Dr. Darren Sheeline. We just get rid of the doctor part. Same thing on page 3, again, page 4, you know, it's just those, just so that they're all consistent. So throughout that, so that was the only thing that I had on April. Did anyone else have any corrections to the minutes for April? All right, I need a motion to approve the April. Brian, Ed, and a second. And Kevin. All those in favor? Aye. Anyone opposed? All right, last set is June. Beth?
I had a couple.
All right.
Page 7. Board action, the motion was made and seconded to approve it. So let's take off the T. this has been the last.
All right. I also had a question on that same page, number 10, up under C, the very first paragraph. Third line down, it says hygiene examination requirements as core office. I didn't know what that meant. We'll be working on creating the application. On page 10, under number C, third sentence down, it begins with hygiene examination requirements, comma, as, and then it says POUR, P-O-U-R. It should be our office, so get rid of the P. All right. And then also on page 6, right before item 6, it said, let the record show the Ms. Hudson. It should be that Ms. Hudson agreed to the terms of probation. So those were the only corrections that I had for that as well. Any other corrections for the June? Is there a motion to accept? And a second, Robert. All right, all those in favor, say aye. Aye. All right.
Mr. Williamson, I think in the class, if one of the board members would volunteer to review minutes prior to complete. I want to, it does help move it along. They review the minutes and then they report back to the board. And I make any corrections and then.
Oh, so let you know prior to,
Right.
if there's, oh, okay. So Cindy's asking that if we review these and we find errors, to let her know prior to the meeting.
Email her first. Okay.
Yes.
Fine.
Okay.
They're well corrected before.
Sure.
Oh, excellent, excellent. I did not realize.
And
that
just
was-
the usual heads up, to email, when you email Cindy, don't email everybody. Just don't want to run afoul of the open door law in terms of unintentionally qualifying as a meeting, so anything business wise, just, you can tell her and you can copy me too, but.
All right.
Email 6 members. So technically you could skirt the law, but I'm not gonna tell you to do.
Okay. Could I ask then, do then you send out minutes again at the end that we approve, that we look over? I don't,
Yes, some of you do in the packet.
as it does.
Yeah, everybody will still have it.
So it'll just show that they're corrected,
Yeah.
you know, like if she amended something,
that'll
so it,
be like the date before,
Right.
for such. Yeah.
Hopefully. we're all over it.
Well, it's sometimes any changes made, that's sometimes, so she came in and we're all.
Okay. So we can save some time.
great. Super. That does make sense. All right, we're going to now go toward our administrative rule hearing. Our first one is the LSA document number 26151. All righty, so we need to swear in, so will the official reporter, raise your right hand. Do you solemnly swear that you will keep complete and true notes of all that transpires in this hearing, prepare a complete transcript thereof from your notes, and faithfully perform all duties imposed upon you as an official reporter under the laws of the state of Indiana? All right. This is a public hearing being held at the State Board of Dentistry on this 7th day of August, 2026, pursuant to the Indiana Code 4-22-2-24. This hearing is convened in room WO64 of the Indiana Government Center South, 402 West Washington Street, Indianapolis, Indiana, at 9:11 a.m. local time by Annette Williamson, DDS. The hearing is being held in person and via Zoom. Notice of this hearing and the full text of the rules were published in the Indiana Register on May 27th, 2026. Purpose of this hearing is to hear public comment regarding LSA document number 26151. Those who address the board are requested to state their name for the purpose of the record and this hearing. Only those who address their comments to the board will be recognized. Individual comments will be limited to 3 minutes in length. The board will consider all comments made at this hearing in deciding what action to take on the rule. Upon adoption of the board and approval by the Attorney General and the Governor, The rule will become effective 30 days after filing with the Indiana Register. My name is Annette Williamson, DDS, and I will be presiding over this public rule hearing. Before I open the floor to public comment, I would like to add that no written comments were received during the designated public comment period between May 27th, 2026 and June 26th, 2026. The board will take comments from the public at this time. You will be given 3 minutes on the floor time. Those that wish to speak should first sign in at the table that was provided. All right, is there anyone from the floor that has comments? Yeah, the public. This is just for public and then we'll go into board.
Yeah, you'll have this.
All right. Seeing no individuals wishing to make comments with regard to the proposed rule, it says I should close it. But is that changed then? Do we leave it open for discussion? Is Amy here?
Well, no, I mean, there was only one public. The concern that led them to implement this change was judicial review. You're not gonna be brought up on judicial review about it. So I'd say no. Go ahead.
Okay, so seeing no individuals wishing to make comments with regard to the proposed rule, I hereby close this public rule hearing. We'll now have discussion from the board. So this is basically just doing the $50 late license renewal fee to both the dentist and the hygienist is all it is. Robert.
I mean, last month we re-upped basically some of the administrative code 828 also. And that's what we're doing this time. Actually, we're adding a $50 fee. This is when you go back and look at this section of 828 in Administrative Code 828, it has to do with other things that we've viewed over the last, 12 years, 11 to 12 years. Several changes, which, we haven't been able to accomplish change in yet, and we're adding to it. Now, granted, at some point in time, I'd say everybody's probably, I would assume everybody is good with the $50 late charge. But we still have things out there that are actually, it even addresses a fee for light parenteral or light conscious sedation, which of course we had worked on considerably to get general anesthesia, moderate sedation, deep sedation, terms like that, re-upped, and we're approving something that's talking about light conscious sedation and a fee attached to it. Has some other fees that we're anticipating changing, like, let's see, another second attempt at the law exam and things of that nature. So this is pretty outdated, so I don't know where we draw the line. Maybe it's not on this one, but, we're working on this administrative code, and we're just backtracking here and leaving several things that are, actually, a couple of those are public health and safety issues that should be addressed, but we're not addressing them with this.
Any other comments on this particular rule?
Just approving these, they go in, and they can't be updated to where we've already updated the others. So we can't change the language on this, correct, at all, just terms and such?
Nothing's updated except for
Correct.
$50 fee.
Yes, but the terminology we're updating on all the other stuff, but this does not have that terminology. So this is then conflicts with the others. So isn't it prudent to try to update this before we approve it to match the other stuff that we're trying to get approved?
And procedurally, Cindy, help me out a little bit here, because this is the final rule hearing, yes? Okay. And it doesn't seem like we hold first rule hearings on these readoptions, these fees. Did we do that?
It's really not a readoption. This is a new rule.
It's a new rule.
We're adding the $50 fee, or just, so we have the $50 fee for late renewals.
Okay.
Everything else will be intact.
Right.
All the changes we were anticipating maybe still be intact.
Yeah. Okay. That's good to know. Okay, so did we arrive here by just having this suggested to the board? The board didn't write these particular
That is
rules?
correct.
Okay. That's where my confusion came in, because usually the process is board writes rules, it gets submitted, go through the process, go through a hearing, a public comment period. And usually at this point, changes are only because unless it's stylistic things, flubs that kind of get caught. Usually changes only come because the public says something and you adjust to that. In this case, you didn't write the rule. So I don't know exactly what to tell you to do, because most of the time that's where a rule would originate, is the dental board doing this. Now, this is an agency-wide thing. So it's not like you're singled out to pass something like this. But yeah, in terms of what has been posted to the public is, I'll say this, you can't make a unilateral change right now and do final passage right now of something besides what has been advertised to the public, because what has been advertised to the public is, if you don't object to this or you don't say anything about this, the board can just adopt this exactly as it is. And if you change something on the spot and say, we're changing this and approving it, the public has not been warned, has not been given their chance in on the process on whatever changes you make, even if the public wouldn't much care. It doesn't matter. We can't decide for other people whether they would care. So if you were going to make changes, we wouldn't be able to do final passage today. But that doesn't mean, I mean, nothing's holding your feet to the fire saying you absolutely have to say yes today. So I guess that's where we are.
My gut feeling is we have to say yes, no, or abstain. But, I mean, I thought it was worthwhile to at least mention this, that we're adding a fee, but nothing else has been accomplished on this yet. We haven't changed anything, so.
My problem is that we're adding a fee for something that is outdated language with our rules rewrite. So when it goes in, and if the rules rewrite goes through, this won't match that on the light printals content.
Can the motion then be that this is approved, that we're adding this fee based upon updating it with what we've already submitted for rules approval, or no?
Well,
It's
nothing
this or
can be,
nothing?
nothing can be added to a final vote right now.
Okay,
Nothing can be changed if we're also doing final approval right now, for the reason that I just said.
so just this or nothing?
That you
Okay.
can't, yeah, and I think Cindy wants to jump in, but yeah, you can't, for the reason that I said, just change something and pass it for final, because then you've slipped it past the public without letting them speak.
Okay. The rule rewrite, that'll go through with the rule rewrite. Whatever you've done in the rule rewrite, that'll be a whole nother rule hearing at a different time. This is the rules that you need to pass now so we can get the $50 late fee back into the rules. So whatever is wrong, different in your rewrite, that'll be a whole nother rule hearing.
Sure. I certainly understand that. So we're giving the public an opportunity to speak today to this rule, and we're voting on that. But the underbelly of this just ain't right. So I just want that to be, recognized.
How does this happen so fast and our other rules rewrite happen so slow?
Well, since it's not me, I don't really want to be the one to answer that, but I mean, I believe this is being done agency-wide across all boards, and it's fairly standard language, and that's why, especially when the boards aren't authoring these originally and are basically being given this as an up or down vote, that's why it's happening quickly, because boards are being asked to go through several other steps.
And if you vote in positive fashion, I mean, you still will have established that $50 add-on for late fees. However, um, that could probably be added with the rules rewrite too. Amy, you want to address this?
Yeah, so. Sorry, the $50 late fee was something that we charged up until last year. And because of the change in the fee rule process, we had to have it more established into actual rule. This was part of a separate rulemaking that we were hoping to do for all the boards under authority that PLA had. Unfortunately, we were told we could not do that, so we had to break it out into separate boards. So now you have a separate late fee rule, $50. Every board charges $50 unless they have a specific rule already or a statute. The reason this one is much quicker than the ones you've been working on is because it is a very much simpler regulatory analysis. The ones that we've been working on for the past several years, and I understand, I get it. It is a very detailed regulatory analysis that we can't just get approved like that from the Office of Management and Budget. We have to go through a process. We have a very detailed cost benefit analysis that we have to do. And so we are working, they have been submitted to OMB for their review. We're waiting on their approval. So we were able to move this one much quicker because the analysis is quicker, the review of it is quicker and different. That's the reason for why those are two different things.
To speak in Amy's support a little bit here, I just know from working on rule readoptions, what she says is very credible. I've been working on one for an extremely simple rule that applies very little in terms of imposition, and I can't believe how many words I have to write about it. So when I say that, what you wrote is extremely detailed. So I mean, what she says is resonant with me and my experience with working on rules unrelated to this. So I'll just say that.
When we are working on rules, again, I think I've explained this before, we have 3 staff members that work on rules consistently. And that's not just the dental rules. That is 33 other boards. On top of the dental review that we are doing, and we have prioritized over the last at least year, 6 months, whatever, we have 8 to 10 readoptions we just had to submit as well, including some dental readoptions that we're trying to get done before the end of the year. So it's a compound of that. It's a lack of staff and capacity, which I'm not using that as an excuse. I'm just giving you the reality of it. And so sometimes these rules that are a little bit more basic, have a little bit less of a detailed regulatory analysis, allow us to get those done quicker. So then we can go focus on these other rules. That makes sense.
Your explanation makes sense, but the whole process does not, as far as it
We
seems
don't
like
have control of the process.
We're backtracking with this thing, but Demi,
I
Any
would
more
control the
discussion?
process if I could, but unfortunately it's not just
Thanks,
mine.
Amy. Any other questions that the board would have for Amy before she exits stage left? Thank you, Amy.
I would make a motion to approve LSA document 26-151, the late fee.
And is there a second? All right.
yeah, I'll second it. You heard what I've got to say, but I'll second it so we get this thing moving and move on from here.
Is there any further discussion? All those in favor say aye.
Aye.
And oppose. Opposes, so 9. All right, motion is carried. Right, we are now going to move on to administrative hearings, and our first one is Miss Jody Daracha. morning.
Good morning.
All right. This is an administrative hearing taking place on August 7th, 2026 in room WO64 of the Indiana Government Center Building, 402 West Washington Street, Indianapolis, Indiana, at 9:27 a.m. local time. It is being conducted pursuant to the laws of the state of Indiana as found in Indiana Code Title IV, Article 21.5, before 9 members of the Indiana State Board of Dentistry in a cause docketed as administrative cause number 202-607-DEN-0004. The petitioner's name is Jody L. Duracha. The hearing is being held pursuant to the request of the petitioner based upon the petition for review of license denial for the application of Jody L. Duracha. The notice of time and place of this hearing was served on the parties required by law on July 28th, 2026. Court reporter has already been sworn in. My name is Annette Williamson, DDS. I am serving as the hearing officer for this board. The following members of the board are seated with me on this hearing: Robert Finley, DDS, Jeff Snoddy, DDS, Edward Sammons, DDS, Matthew Kochman, DDS, Crunchy Wells, DMD, Kevin Ward, DDS, Twyla Rader, LDH, and Shelley Gregg, consumer member. At this time, I will request that any board member who believes that he or she cannot give this respondent a fair hearing and render an impartial decision to remove him or herself from the hearing. Is there anyone? As a reminder, this hearing is open to the public and being streamed live on the internet. It is the responsibility of the parties and counsel to ensure any protected health information and other confidential information necessary to the party's case in chief to be de-identified prior to disclosure. Failure to properly protect patient information could result in objection and exclusion of testimony of the witness. May we have appearance of counsel? You do not. So do you understand that you have the right to be represented by an attorney in this matter?
Yes.
Right. Do you wish to proceed without an attorney present?
Yes.
All right. Will all those who know themselves to be witness or who may be witnesses in this cause, please stand and raise your right hand to be sworn.
And just given the nature of the grounds on which she's challenging, whoever has personal knowledge of how she was served, because she's claiming she didn't get it, it would be good if we could get their testimony just briefly. Do we know who did that? No, the personal appearance that she was not here for, and therefore led to the denial. Okay, unavailable. All right, fair enough. Thanks.
All right, raise your right hand. Do you and each of you solemnly swear or affirm under penalty of perjury that the testimony you are about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Right. You may be seated. The parties in this matter are hereby notified that the board will take official judicial notice of its file and record in this matter. Do you wish to make an opening statement?
I renewed my license and I divulged that I got an OWI. I submitted all my stuff. Then on March 18th, I received a email that stated that I was able to practice while under review. I called the IPLA several times inquiring about it, what I needed to do. They said to wait until I was notified. I did not get any notifications through email or through the mail.
All right. Does the board have any questions for?
Do we have a record of an IPL email to her email address?
Do I need to be sworn in?
Yeah, it's probably best practice.
swear and affirm under penalty of perjury that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I will.
And do you want to state your name? before-
My name is Cindy Vaught. I don't have records since Dana sent it. I wasn't able to pull that. It was under her email.
Okay, so I would suggest that the board dig into beyond the question of service, which, if she says lack of actual service, it's generally best to give some latitude to a person who says that they didn't get it, especially since she's trying to participate now. But, the other thing you're gonna wanna get into is the only reason there was a PA to begin with is because there is an OWI in the background. So just her establishing that you believe her that she didn't get it and isn't here, is only one part of the puzzle, because this is your chance to also, you still have to decide whether or not your decision is one that you're uncomfortable with or comfortable with.
Since we can't confirm nor deny, I mean, we're gonna, I myself will believe you that you didn't receive it. If your probation is over, criminal probation the term is over, correct?
Yes.
Yes, and that's what we have as noted last time. So, I have no further questions.
Can I also add that I did request the emails sent back to me that I was supposedly have gotten? And I was told by somebody in the IPLA that they cannot do that. So I looked in my spam, I looked everywhere in my email. I have gotten emails that started on, I received them on July 21st. And as far as I know, I've gotten all the emails since then, but I did not receive anything before that since March 18th.
Any other questions?
Yeah, just a couple. So from my notes, correct me if I'm wrong, this was a first time offense for you and you've had
Was.
no incidents since this event?
No, sir.
Okay, thanks.
And you're still practicing full-time?
I have not practiced since July 21st, when I received the email notice.
Okay. Is your intent to go back to practice?
Yes.
Okay.
Any other questions? All right, there's another part pursuant to IC 25-1-9-9A6 and IC 25-1-9-15. The board shall consider a practitioner's ability to pay the amount or cost assessed. Does the respondent wish to present evidence for the board's consideration regarding the ability to pay any amounts or costs that may be assessed?
You can't actually find her in this instance anyway, so that part, I understand you were given a script. I'm just
Okay.
saying that the board doesn't even have the option, so we probably don't need to.
All right, thank you. All right, they've changed it according to Amy now that we don't close this and go in discussion, that you're going to have a chance to do closing statements, and then the board will make any deliberations and voting on record. So all of these we do this on record. So again, Mr. Archer, do you have a closing statement?
I just, if I knew about the hearing in April, I would have been here. If I missed the April and knew about the June meeting, I certainly would have been here. I did not find out about it until that Monday afterwards. And like I said, I have call logs that I've made since March to the IPLA, and all I was told is you'll be notified, nothing has happened. Then when I called on that Monday after your meeting, they said, oh, you missed the meeting Friday. So I'm just with two different agencies that I'm dealing with. I'm dealing with the board and the IPLA. I don't know what happened. And again, I requested the emails sent to me. And they said they cannot do that. I was also told that sometimes emails, they do delete emails. So I've been practicing for over 40 years. I love what I do. And this whole instance that happened a year and a half ago is humiliating in itself. And I would never have missed a meeting or not done what I was supposed to.
Thank you. The board will now go into deliberations and voting, at which point, Mr. Acha, you're not able to speak any further. It's
Okay.
just discussion for the board here.
First off, I want to apologize if this indeed did happen. And the stress that has been on you. I believe possibly the email she did get after this last meeting of the denial came from a different email address, more likely the Cindy's and the Dana's, and that's might be why she got it. That possible? Yeah. And I think it's kind of clear she's done with her probation. I move to reinstitute her license.
I second that.
All those in favor say aye. Anyone opposed? All right. These proceedings, according to notice, are hereby adjourned until further order of the board.
Okay, does that also include my anesthetic license? Is reinstated?
Yes.
And is this effective immediately?
The license, due to the fact that she had. My understanding, due to the fact that she appealed, she went back to ballot to practice while being reviewed. Is that correct?
I don't know, but I hope so. Let me, let's verify right now. That's easily verified right on the spot. So
That's what we have her under. She's been valid to practice.
it says valid to practice while reviewed. So yes, for it to be finalized, you have to wait on an order, but in the meantime, you were protected and you don't have to. Yeah, you can work Monday. Yes.
Thank you.
Did-
Thank
Did
you all.
excuse me, did you pay your fee for your anesthesia permit to renew it? Was it paid?
Yes. In March 1st?
He's looking at it. It's paid. It'll be valid to practice.
Thank you. Do I
Although
stay or do I leave?
You don't have to. The anesthesia permit does say expired, right? That's the one that between. Okay. Okay. Okay.
Thank you.
All righty. Our next administrative hearing is Peter Andrews, that one. All righty. Not present. Okay. This is an administrative hearing taking place on August 7th, 2026 in room W064 of the Indiana Government Center Building, 402 West Washington Street, Indianapolis, Indiana, at 9:42 a.m. local time. It is being conducted pursuant to the law of the state of Indiana as found in Indiana Code Title IV, Article 21-5, before 9 members of the Indiana State Board of Dentistry in a cause docketed as administrative case number 202-604-DEN-0002. Respondent's name is Peter Andrews. The notice of proposed default order was issued in this matter and filed on July 10th, 2026. The notice of proposed default order was served on the parties required by law on July 10th, 2026. Notice was also given to the Office of the Indiana Attorney General. A response to the notice of proposed default order was not received from the respondent. Purpose of this hearing is to conduct a further proceedings necessary in order to conclude this matter. The court reporter is already signed in. My name is Nat Williamson, DDS, Board President, and I'm serving as hearing officer of this board. The following members of the board are seated with me on this hearing: Robert Finley, DDS, Jeff Snoddy, DDS, Edward Sammons, DDS, Matt Kochman, DDS, Crunchy Wells, DMD, Kevin Ward, DDS, Twyla Rader, LDH, and Shelley Gregg, our consumer member. At this time, I will request that any board member who believes that he or she cannot give this respondent a fair hearing, an impartial decision to remove him or herself from this hearing. As a reminder, this hearing is open to the public and being streamed live on the internet. It is the responsibility of the parties and council to ensure any protected health information and other confidential information necessary to parties' case in chief to be de-identified prior to disclosure. Failure to properly protect patient information could result in objection and exclusion of testimony of the witness. May we have appearance of counsel?
DHE Ian Matthew for the state.
All right. You have a witness, so will all those who know themselves to be witnesses or who may be witness in this cause, please stand and raise your right hand to be sworn. Do you want to state your name for the court reporter and spell it? Do you solemnly swear or affirm under penalty of perjury that the testimony you are about to give in this cause will be the truth, the whole truth, and nothing but the truth? All right, be seated. The parties in this matter are hereby notified that the board will take official judicial notice of its file and record in this matter. You make an opening statement, please.
Thank you. So members, we're here seeking discipline of Peter Andrews' dentistry license. It's hard to appreciate that something like this can still happen in modern times, but the evidence will show that the respondent applied for licensure by reciprocity here in 2024 using an Ohio
I'm
license.
sorry, Mr. Matthew, has default happened yet?
No, sorry, thank you. So an NOPD was issued on this matter at the board's last meeting. NOPD was actually issued on July 10th. So no response was received, as the president said, so I'll go ahead and move for the respondent to be held in default.
I advise granting that. It looks, as long as there's no issue with service and he would let you know if there was, that's pretty automatic results. So I would suggest making a motion to hold the respondent in default. We need that in order to proceed.
I second that.
Okay, all those in favor? Anyone opposed?
Thank you, members. Thank you, counsel. So the evidence will show that the respondent applied for licensure here by reciprocity in 2024 using an Ohio license. He failed to disclose that he had previously practiced dentistry in Canada and had been disciplined there. In fact, his license was revoked. He failed to disclose this when he applied for his license in Ohio, but eventually Ohio did find out. They conducted an investigation and notified IPLA. IPLA then filed a complaint against his license with us. So after investigating the Canada discipline, Ohio revoked his license, his Ohio license in February of 25. Our administrative complaint has two charges here. That's fraud or material deception for failure to disclose his Canada discipline on his original application here, and then discipline in another jurisdiction based on Ohio having subsequently revoked his license there. So at closing, I'll ask you to find him in violation on both counts as alleged, and then revoke his license as Ohio did. Since this is a default, we'll go ahead and proceed into testimony if it's okay. All right. State will call Deanna Silva. Ms. Silva, we're going to share a microphone here. So can you tell us where are you employed?
The Indiana Office of the Attorney General.
All right. And what is your position there?
I'm an investigator.
And can you give the board an idea of your regular duties as an investigator?
I investigate consumer complaints filed against licensed individuals.
Okay. And are you familiar with the respondent in this case?
Yes, I am.
All right. And how so?
I was an investigator assigned to the consumer complaint we received.
All right. And have you reviewed the investigative file and the evidence portfolio in preparation for this hearing?
Yes, I have.
All right. And so tell us, how did the respondent's conduct here come to your office's attention?
A consumer complaint was filed by IPLA with our office.
All right. I'm going to show you here Exhibit 1. Can you identify this?
Yes, this is the consumer complaint that we received.
All right. And this was filed against the respondent?
That's correct.
All right. And as far as you're aware, is this a true and accurate copy of the complaint and the attachment submitted?
Yes.
All right. I'll move to admit Exhibit 1. Okay. So Ms. Silva, tell us what the allegations were here.
So IPLA received an email from the Ohio State Board of Dentistry, and they said that they were investigating Dr. Peter Andrews. And while they were investigating, they found that he had previously held a license in Canada under a different name. And then that was revoked in Canada, and he never disclosed that on his Ohio license application.
Okay. And then this attachment here is an email from the Ohio State Dental Board. Is that right?
That's correct.
And the complaint mentions an alias. Were you able to confirm whether the respondent formerly went by another name?
Yes.
Okay. And what was that name?
Khalid Hashim.
Okay. And when did the respondent apply for licensure here in Indiana?
I believe it was March 5th, 2024.
All right. And was that by reciprocity?
Yes,
And it was using his Ohio license, is that correct?
that's correct.
All right. I'm going to show you here Exhibit 2. Can you identify this for us?
This is the license application that Peter Andrews submitted to the Indiana Board of Dentistry.
All right. And except for the redactions, as far as you're aware, is this a true and accurate copy of that application?
Yes.
All right. So I'll move to mid Exhibit 2 as well. So Ms. Silva, let's just look at a couple different things on here. Let's look at the questionnaire. So can you tell us, how did the respondent respond to question 1? And I'm going to read question 1 here. It says, has disciplinary action ever been taken regarding any license, certificate, registration, or permit that you hold or have held? How did he respond to that?
He responded no.
Okay. Did he disclose anything about having been licensed in Canada?
He did not.
All right. Were you able to find any records of the respondent having been disciplined in Canada?
Yes.
All right. And are there any records collected of the respondent having been disciplined in Ohio based on his Canada discipline?
Yes.
All right. There's many pages here, but I'm going to show you here Exhibit 3. If you could just identify this collectively.
This is the licensing file that we received from Ohio regarding respondent.
And as far as you're aware, are these true and accurate copies of those records that were received?
Yes.
All right, I'll move to Exhibit 3 as well.
So moved.
So Ms. Sybil, we'll kind of start at the beginning here. The first few pages contain disciplinary charges. What violations were alleged here?
It was alleged that respondent had employed or cooperated in fraud or material deception to receive his license in Ohio by not disclosing his discipline in Canada.
Okay. The bulk of the files here are disciplinary records from Ontario. Is that right?
That's correct.
All right. Can you just briefly review his discipline there?
So he was suspended for about 5 months in Canada, and then that was in 2013, and his license was revoked in 2014.
All right. And this was based on a variety of patient complaints that had been filed against him in Canada. Is that correct?
That's correct.
Okay. So we'll flip through mostly to kind of the end of the document here. That's page 77. So what was the outcome of the respondent's Ohio disciplinary case?
His license was permanently revoked in Ohio,
All right. And when was that order issued?
February 3rd, 2025.
Okay. As far as you're aware, is Indiana the only state where the respondent is currently licensed now?
Yes.
Okay. Did you receive any communication from him during the course of your investigation?
I received a voicemail with no callback number, essentially saying that he was not practicing in Indiana and he didn't plan to practice in Indiana.
Okay. Okay. I don't have further questions. Members?
Does the board have any questions?
No, we're prepared to go to closing.
Closing?
Thank you. So I think the evidence is clear here, members. Like I said, it's hard to believe that something like this can still happen. The respondent practiced in Ontario under his former name. His license was revoked in 2014 there by the Royal College of Dental Surgeons. If you care to look through the records in Exhibit 3, you can see kind of a variety of different things that he was doing there to warrant revocation of his license. You heard that he applied for a license in Ohio. He failed to disclose his prior discipline there. He applied for a license here in Indiana using his Ohio license. After that was granted, he also failed to disclose it here. His license was ultimately revoked by Ohio in February of 2025 on grounds similar to those allowed under Indiana law. That's fraud and material deception to obtain a license. So our administrative complaint has two charges. First count is fraud and material deception to obtain a license. That is for answering in the negative to question 1 on his 2024 dental license application. And then count 2 is discipline in another jurisdiction. That is for having his Ohio dental license revoked in February 2025 on grounds similar to those under Indiana law, which is 25194A1A or 25194A7. So I think really the only proper discipline here is to revoke that license so that he doesn't have a license to practice in any of the United States anymore. Thank you.
Thank you. So now we'll do deliberations and motion on record.
I would just quite simply motion to revoke.
Any further discussion? All those in favor say aye. Aye. Anyone opposed?
Thank you, members.
Thank you.
Quick discussion. So, okay. As I understand it, this happened in February 2025, and this person had a license for another year. I mean, the original was back in 2014, but 2025, this person lost their license in Ohio. We didn't know or get notified until they tried to apply again, and Ohio gave us communication, I believe, or such. And that was in March of 2026. I'm going to say that we need to discuss at some point in time, being a member of the AADB, to get monthly board reports, and to be able to check their clearinghouse, that we could have found out sooner than that.
I don't, intentionally want to call you out, Cindy, but the date on this email from Ohio was June 27th, 2024. So do you happen to recall why it took 2 years for it to end up on our agenda? If you got emailed 2 years ago from Ohio?
I had to file a complaint with the Office of the Attorney General. A complaint was filed. So that's the reason they've been investigating it.
Yeah, I mean, the only thing at the board level, unless you have a probationary licensee, board staff can't just go to the point of an order to show cause or something like that. They find out a misconduct, they do have to refer it out. They can't just bring somebody in for a hearing on their own power. So it does have to go to an investigative status.
When you look at the charges, this is like immediate endangerment of the public, though, what kinds of things he was doing. And so that calls for like an emergency endangerment of the public type of hearing. And for this to go on 2 years is
That's
unacceptable.
perfectly valid feedback to give the OAG and their handling. So that is perfectly fine. But yeah, as far as what the board can do, there are limits in it.
Taken. Anything else on that? Thank you. All right, our next administrative hearing is Dr. Alan Daniels. Dr. Daniels.
It's okay.
Oh, it doesn't matter which one.
Law doesn't govern that, so.
No, you're, no, you sit there, Dr. Daniels.
We'll just do this for a while.
Sorry.
Musical chairs.
All righty. This is an administrative hearing taking place on August 7th, 2026 in room W064 of the Indiana Government Center Building, 402 West Washington Street, Indianapolis, Indiana at 9:59 a.m. local time. It is being conducted pursuant to the laws of the state of Indiana as found in Indiana Code Title 4, Article 21-5 or 21.5 before 9 members of the Indiana State Board of Dentistry in a cause docketed as administrative cause number 202-507-DEN-0005. The respondent's name is Alan Dale Daniels. The notice and time and place of this hearing was served to the parties required by law on August 5th, 2026. Probation withdrawal. The purpose of this hearing is to consider the respondent's petition to probation withdrawal. My name is Annette Williamson, DDS President, and I am serving as hearing officer for this board. The following members of the board are seated with me on the hearing: Robert Finley, DDS, Jeff Snoddy, DDS, Ed Salmons, DDS, Matthew Kochman, DDS, Crunchy Wells, DMD, Kevin Ward, DDS, Twyla Rader, LDH, and Shelley Gregg, Consumer Member. At this time, I will request that any board member who feels that he or she cannot give this respondent a fair hearing and render an impartial decision to remove him or herself from the hearing. As a reminder, this hearing is open to the public and being streamed live on the internet. It is the responsibility of the parties and counsel to ensure any protected health information and other conditional information necessary to the party's case in chief be de-identified prior to disclosure. Failure to properly protect patient information could result in objection and exclusion of testimony to the witnesses. May we have appearances of counsel, please?
Rebecca Hammond, Deputy Attorney General on behalf of the state.
You do not. Do you understand, Dr. Daniels, that you have the right to be represented by an attorney in this matter?
Yes, ma'am.
And do you wish to proceed without an attorney present?
Yes, ma'am.
All right. Will all those who know themselves to be witness or who may be witnesses in this cause, please stand and raise your right hand to be sworn. Please state your name for the court reporter and spell it.
Alan Dale Daniels, ALLEN, DAN, excuse me, DALE, DANIELS.
Do you and each of you solemnly swear or affirm under penalty of perjury that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
The parties in this matter are hereby notified that the board will take official judicial notice of its file and record in this matter. Opening statements.
So this is his petition, so it is his case to present.
Do you wish to make an opening statement?
I'm here to petition to withdraw and hope the board sees fit to do so.
So just to give the board some procedural history of the case, in September of 2025, you issued a final order accepting a proposed settlement agreement. The underlying facts of this case were related to petitioner inappropriately texting a patient and saying he would like a relationship with them. You have the final order in your file and all of the details of that case. So he did admit to this conduct. He stipulated to 2 violations of lewd or immoral conduct and failure to keep abreast of professional theory and practice related to, failure to abide by some ethical standards. The sanction that you imposed, he agreed to, was probation for not less than 1 year of that final order. All the different standard terms that you have in your probation, a few I wanted to highlight that were some outliers were the inspection of his dental practice, at least one, by the compliance officer, and you should have a report of that in your file. He had to re-engage with therapy and have a therapist submit a letter regarding his progress. He also had to abide by some personal appearances before the board, so I believe you have seen him before, and then a fine of $1,500. Again, it is his burden today to demonstrate that he has complied with all of those terms of his probation, and the state expects to not have an objection today to a withdrawal. Thank you.
Questions that the board have for either party?
So it is his case to present. Just procedurally, he would present a case, and then I'm prepared to, when he rests, present a case.
Okay. Do you have anything else additional? to that?
I want to say that I have complied fully and have received benefit of therapy. It was beneficial. And I feel like that I am ready to move forward.
Dr. Daniels, I just had a few questions for you. So could you provide the board details about your work schedule and what your current practice looks like?
Current practice is much less than it used to be. This was pretty devastating. Lost staff, had to replace staff at a time when hygienists are almost impossible to find anyway. So it's difficult to keep up the numbers. So the practice is down, but I do have a part-time hygienist and full staff otherwise. And we're moving forward doing dentistry on a daily basis,
Do you work Monday to Friday, full-time?
Monday through Thursday.
And are you the only dentist in the practice? And what type of dentistry do you practice?
General practice, I do place implants as well.
And can you just share, I know you've highlighted it in your opening a little bit, a term of the probation was to complete some continuing education. Can you share with the board, what have you learned from the professional and ethics continuing education that you took?
Ethics and boundaries were the 2 focuses of those continuing education courses. I studied those a lot. I took it from different viewpoints, from different healthcare backgrounds. I looked at it from the aspect of a person who is actually a therapist. I looked at it from a dental viewpoint. I looked at it from several viewpoints, trying to gain as much insight as I possibly could for compliance and to understand and appreciate and become a better citizen and person.
And based upon what you've learned, how has that shaped boundaries that you implement in your practice?
Well, I think that it along with this whole procedure forced me to get back in touch with the things that I learned. I grew up in church, and it brought it all back, and those things together helped me to assess things, I think, in a better way.
And you mentioned therapy. Are you still engaged in that and planning to, if your probation is withdrawn, still engaged with that?
I completed my therapy. The therapist felt I didn't need to go forward with that, although on my own, I intend to get back to a therapist anyway.
And hypothetically, in the future, if you do have a patient who, let's say, quote unquote, was making an advance, what steps would you take in the as a professional in that situation?
For one, I would ignore that possibility, and I would proceed with normal dental treatment without any change in what I do with everyone else.
And if your probation is withdrawn, are you planning on staying in practice in Indiana, or do you have any specific plans for your practice?
I'm going to continue to practice. I am applying for licensure in Ohio and probably will another state because that will allow me to do some travel dentistry. I need more time in practice, more hours of income. And so my practice is not what it once was. It's still a good practice, but it takes a while to build it back up. And without hygiene, it's hard to do that. So yes, I'm going to stay there, but I'm hoping to find some work working on military bases on a weekend basis so I can add to my income without having to close my practice.
Are you still planning to have your primary residence in the state of Indiana?
I live now, just moved this week to Harrison, Ohio, which is only 5 minutes from my office.
State has no further questions for Dr. Daniels.
Now, does the board have any questions for either party?
Dr. Daniels, you have completed all 16 hours
Yes,
of CE. Okay. Okay.
more than that.
Okay. Thank you.
Dr. Daniels, a closing statement?
The state would have one more witness to call.
Oh, I'm sorry.
I just wanted to call the board director, Ms. Vaught.
I'm sorry. I forgot.
Ms. Vaught, can you please state and spell your name for the record?
Cindy Vaught, CINDY, VAUGHT.
And how are you currently employed?
I'm the board director for the dental board.
And in that role, do you have access to his full file with IPLA?
Yes, I do.
And before today's hearing, have you reviewed that file?
Yes, I did.
Can you verify to the board, based upon your review, has he complied with all the relevant terms of probation?
Yes, he has.
The state has no further questions for this witness.
Now, we can have closing statements.
I'm looking forward to my stress level going way down after today. And I hope we can proceed amicably.
Thank you. So I think this case does highlight that his past conduct as a professional, you're always responsible for yourself, your behavior, and maintaining those boundaries with a patient. I think he has illustrated today through his testimony, he's become self-aware of that and what he's learned in regards to his professional obligations and duties and plans to continue to abide by that with his practice. Additionally, you had testimony from the board director that he's complied with all the other terms of his probation. I will note just a small caveat for timing as to this for the board. We're a little bit early as far as a year. However, it does take you 90 days to issue an order. And so even though the hearing is a bit early on that year minimum, theoretically an order could come out in that year timeframe. So just wanted to point that out for you if anyone was wondering that. But as far as from the state's perspective, we have no objection to withdrawing the probation. Thank you.
Yes, I see we're like maybe just a month because his probation started September 15th. So about a month. All right, the board will make any deliberations and voting now on record. So discussion.
So yeah, I think the confusion probably came in at a year because we are a year from the time the settlement was filed and not when it was accepted, which is when it's supposed to toll, but that's where we are.
But we're okay then.
Yeah, it's that, well, it's always, I mean, it's generally best to abide by the letter of the order. The fact is, the probation withdrawal statute, the standard under the law is just whether you believe the deficiency that led to the probation has been remedied. So it's up or down on that. The terms and conditions are a very good guidepost, but it's what you're comfortable with.
Discussion from the board or a motion?
Seems like.
Yeah.
I'll open it up with a motion to withdraw probation.
Any further discussion? All those in favor say aye. Aye. Anyone opposed? Motion carries.
Thank you.
Congratulations.
Thank you. I do have a question or two, if possible. Just talking about timing again, when will this actually be on my record that I'm no longer under probation? And one of the reasons I'm asking is I am trying to work some different places to get hours. Ohio is one of those places. I put in for a license there by reciprocity or to reinstate because I used to have a license there. And they are holding off because of my probation and were supposed to let me know in October. So when will I be able to tell them that that is no longer in effect? And I would ask if at all possible, could I have someone from their board speak to someone on this board to verify?
Your probation status will change when you get the order. So be on the lookout for that. The timing is as quick as we can get it out, but we don't want to promise an exact time. As far as establishing at least what the board has decided here today, this will be hosted on video online. You should be able to point to them proof that the board has approved this and that it's awaiting a formality. That said, the formality is still something you have to do, and until you get that, the probation is going to be in effect.
Normal time frame, 60 days, 30 days? I know it's a guess, I'm sorry.
Just a rough.
Ballpark, Cindy, me, I don't know. I mean, I won't take that long to get an order drafted, but there's multiple parts to the process, and I don't know.
I understand. Yeah, I was just trying to get a guesstimate. And would there be an avenue of communication between this board and the Ohio board, if need be? I just simply want to make sure that they understand that this has been lifted and.
Well, yeah, if again, you can provide them a copy of the order as soon as you have it, and you can provide them a link to this video even sooner. I would say, which isn't the lifting of your probation, but is the approval of the lifting of your probation. That's where we're at.
Cindy, could I possibly get an email with that link to the video?
You just have to go on the IPLA website, so IPLA.gov, and then it has every board listed. So you just click on the dental. It's very easy to navigate. You just click on the dental and it'll bring up this feed.
Okay.
It's very easy to find,
Okay.
very easy to find.
Thank you.
Uh-huh.
Done?
Thank you very much.
Thank you very much.
Just FYI, I saw pop up on the Zoom, direct message from Nicole Downing, who's an in-person, but I didn't see what the direct message read, but I don't know if you guys can get in there. She sent a, oh, okay, cool.
Because she's up next. Is she en route or? And we can't do that online. Because we can't, yeah.
I spoke with her yesterday and I did leave her off of the agenda. she did call yesterday and said that she wanted to be on there. And I have put her on there on the amended agenda. But I just assumed she would be here. We did not talk about being online.
All right, so she is here for a personal appearance for probation. So obviously she's online, she can hear us, but we can't hear her, so. Is that okay for the board to tell her, we'll just move on to the next and we'll come back? So yes. Really? All right, so let's move on to applications. And our first one is Dr. Bothra.
So we could sit here if we want.
It doesn't matter.
We run a tight ship here and
Sorry. All right. So you are here. We made a decision at our last meeting, June 5th, to deny the license. So you are here to review the board's decision to reconsider the denial.
Bradley Keffer for Dr. Bothra. May I proceed?
Yes.
Very good. Thank you for permitting the board for permitting us to appear. Dr. Bothra appeared at the last presentation, but did so virtually via Zoom, and I don't think she spoke to the board at that time, so it was an on-paper denial. A subsequent review, we noted that there were some deficiencies with the presentation and some additional information for the board we thought would help the board in reviewing that decision to bring her in line with board precedent and hopefully the granting of an unrestricted dental license. In June, the principal concern was that Dr. Bothra had not completed her program, and I wanted to address that first because there's a distinction in the statute that wasn't in front of the board at the time, which was the completion of the clinical component of her program with just a one-year research component at the tail end. So her program at Boston University was an initial 1 year of clinical research, 3 years of clinical practice, followed by 1 year of additional research. So she completed the clinical practice component, 3 years, or that 3-year clinical practice component on June 4th of this past year. And we provided letters of certification that she completed that program as well as that program is CODA certified. I would note that through the exhibits, Exhibit B in particular, that she completed her ADEX general dentist examination, every component, including restorative sections. The same examination, Exhibit A, a full active unrestricted Washington dental license, which it was issued by examination. And then Exhibit C, her MPDB. Exhibit S, which was submitted, and I apologize, I submitted it this morning because we got the letter yesterday. And I don't know if Ms. Vaught was able to upload that. Thank you so much. Was the Boston University registrars confirming that the orthodontics program is CODA accredited, and obviously the commission's listing. A couple of quick notes about Dr. Bothra. She earned her dental degree in India after a 5-year program which covered general dentistry. She completed her Master's of Public Health at the University of Minnesota, and in July of 2022, she began a combined orthodontics program at Boston University. Her first year was research, as I indicated before, and then followed by 3 academic years of clinical training, treating individuals under faculty supervision from July of 2023 until June 4th of this year. Dr. Will, the departmental chair and director, is certified that all of the programs, all the clinical treatment components have been completed and finished, and that all the requirements of the orthodontic certificate are finished. She is just missing her component of research, which is that last year, which her program is permitting her to do while working, which requires an individualized assessment of the student to make sure they're capable of doing work and completing their academic research components as well. Boston University holds a conferral date, which is when the combined program, both research and clinical, end. And that's the conferral date that was listed as 2027, which I think, and I don't mean to speculate, the board knows what the board's concerns were, but I think that that might have been part of the initial issue when presentation before the board, is that she still had this research component to follow the clinical component, which showed a conferral date of 2027, which then would lead to the natural assumption she hasn't finished her clinical programming. But that clinical programming, I think, was cleared and finished, and that's why I provided the documentation to the board listing that. And then obviously Washington, State of Washington has reviewed her by examination, examined her, and felt free to give her an unrestricted license. She comes to Indiana and has received an offer of employment here in Vigo County as part of a family practice and as part of a larger practice in dentistry. She comes here because her family, in particular her brother, is relocated to the Midwest, and she wanted to be closer to family. And here in Indiana presented that opportunity. And so that employer, even based on the fact that we filed this reconsideration, has extended her offer to continue past this reconsideration, would like to have her as part of that practice. And so both her and I are happy to answer questions. I submitted a fairly healthy exhibit packet, and I'm sorry about papering the board in that respect, but I wanted to lay out the letters that spoke to her qualifications in this, her transcript, as well as the nature of that clinical program. I liken it in my mind as sort of a dual degree. They often tell us lawyers we can get a JD and MBA if we're sadists. And so we can go in and get these 2 degrees, but she's completed the component that I think would be of most interest to the board. So obviously she's here to answer any questions, and obviously she didn't have the opportunity to answer your questions at the last board hearing, but our hope is that upon answering those questions, she'll more align with previous precedent this board has indicated as acceptable. Thank you.
Questions and discussion from the board?
I know my vote last time was because I thought the program was not completed yet. I saw the 2027 date, and I'm going back and reading the statute too, and we need the transcripts and notice that the clinical program's completed, and I think that is satisfied from the testimony you just gave, so thanks.
Thank you, sir.
Other discussion?
I have a question on that.
Yes.
Do you have an actual diploma there? Please have your.
Sorry, I'm sorry, diploma of,
Your MSD for your orthodontic.
not
training?
yet. It's part of the Boston University, how they process it. They process both the degrees together. They were able to give me the letter that certifies along with other support letters, but it's just how registrar processes it. I did ask them, they mentioned that they can only give both of them together in 2027.
Okay, so they don't separate the two.
But at the end, in the end, I will receive 2 kind of degrees, one certificate and one other diploma in 27. But right now they said they cannot give me one and hold off on the doctoral. Although my research is non-clinical, it's a lot of coding. I'm developing an AI-based model for some processes in orthodontics. It's completely non-clinical and does not even require me to be in person there.
Okay, thank you.
So your training then that you're getting at Boston University, your clinical practice, was any of that general dentistry or was it totally ortho?
The training was orthodontics, but I did did practice general for my ADEX and CDC exam.
Because I believe that was one of the concerns that the board also had, is that because your dental degree is from a non-accredited college, then when you do a residency program, the board, because you're applying for a DDS, which is a general license, that your research has to be in general dentistry and not a specialty, because there isn't a license for a specialist. So that was one of the reasons for the denial as well.
And I think to clarify, and obviously Dr. Bother can speak to this, it is an accredited program, the program that she's currently in. We provided that as part of the
Right,
supplement.
and I understand it's accredited, but the board looks upon it as that we want that residency to be in general dentistry, because that's what she's applying for, is a general dentistry DDS license. And if that entire program, even though it was accredited, was done as a specialty, we're granting her a general license. So that was part of the discussion as well. So if anybody else wants to add to that, or
Yeah, and in 828, number 6, it does say, um, completed a clinical training program of at least 2 years of an accredited student that recently ensures a level of competency equal to that of graduates of accredited dental colleges determined by the board. A general practice residency program at an accredited institution, or an advanced education general dentistry program. So and this has been my point for quite some time, we don't offer specialty licenses. And when we give a DDS, we give carte blanche to practice any kind of dentistry, even if you may stay in your lane in your specific specialty. We can't protect the public that you will completely do that. So that is my point.
So I know we have talked about this a lot, but I know I've thought about this and I've thought about my colleagues at the dental school. I think about all the specialists that I know. They go and they do their specialty training. They never revert back to general dentistry. And I know the state of Indiana doesn't have specialty licenses, and I think as a board, maybe we're thinking about this in the wrong way. In this particular case, the problem that I have is that your degree is not conferred. And I'm really sorry, I'm really stuck on that, because when we license anybody, that degree has to be conferred in order for the license to be granted. And I hate that Boston does not give you 2 separate degree conferrals. And that's my problem. I wish they gave you 2. Because what happens in this year if you don't finish your research? That means you don't get that conferral in August of 27.
So my requirement for my research was that I finish 1 project and have a manuscript. I did finish 2 research projects. I'm working on the 3rd because I still have 1 year and I'm committed to whatever my research director asks me of. So just for the requirements of my research, and I understand your point that until it's there in your hand, it's not there. But it just have also met my research requirements. I do not have, that's correct, I do not have the diploma
And I'm
yet.
worried that if we granted it, that would open the door for others that were like, oh, well, I'm almost done. It's really close, but I just don't have the degree conferred, because that's, the degree has to be conferred. It's a sticking point for everybody that graduates.
And I would note that in part of what I think Dr. Both was trying to say is that the granting from her perspective, from an academic standpoint, is a kind of foregone conclusion. She's quite frankly an overachiever in this space. And so we want to just make sure clear, if the board was concerned about carving out a niche, I don't think you're going to find a lot of people who can walk through the niche that would be created there, because of virtue of the fact that she's done 2 projects in 1 year span. She's doing a 3rd in artificial intelligence, doing advanced modeling, that this is the type of individual where, quite frankly, if there was going to be the exception, that maybe it would be conditioned. Maybe a licensure would be conditioned upon presenting that final conferral to the board. But I just want to speak into that concern.
I have a question. If you just said tomorrow or Monday, you go in and say, I'm done with this research, would they grant you your clinical degree?
I'm not sure. The program is 48 months CAGS, which was the certificate, and 24 months research, which is the research portion I'm doing. I really do love research. That's why I did my master's in public health. I've worked at the University of Minnesota for 3 years as a dental research manager. So I was within the dental school. And that's why when I was asked to pick between an MST and DSCD, because I was definitely given 2 options. When I matched into BU, I did pick DSCD by my own choice because I love research. So I never even asked them that question. I did ask them the question if they could give me a certificate when I was applying for licensure. But I'm not sure, I never even asked them because I really love research. I really love going back home coding. It gives me so much more peace.
I think that would be beneficial to you to ask them for this board. Thank you.
Matt?
Yeah, I just want to thank Twyla for bringing that question up. I guess I've had confusion on this conference versus completion question. So to be clear, the degree has not been conferred yet. That is still August 27. And it's clear in statute that the degree has to be conferred, and the date the degree was conferred.
Would the board, if that is truly a concern for the board, and obviously Dr. Bother wants to speak into all of the board's concerns, would the board consider tabling this so that we can seek that information out from the university to speak into the board's concerns?
And it's not necessarily a concern. It's just the way we have to do business. I mean, every student that graduates and seeks licensure, they have to prove that that degree is conferred before the license is granted. And it's usually the last piece of information that the IPLA gets from the institution because it's the slowest piece coming. Because I'm an educator, I know how slow that piece of paper comes.
And I think part of it might have been a communications difference in that my client had reached out to IPLA, received that if you had completed a clinical program that's certified, that you could apply and receive licensure. So I think there might have been just a miscommunication about that.
So I would motion to table so that they can go back and contact BU and.
I'll just answer your question through a microphone. There's no grand secret. She was asking about the possibility of withdrawal, but my answer is their request to table is based on whether or not you think that you can get to possibly yes by the end of this process, not necessarily today. And tabling is perfectly appropriate if you think so. If you think it's even in play, you're not promising anything. You're just saying you're keeping it open, that you don't necessarily think that this is doomed to a no.
And do we need a motion for that?
It just happened in a second.
Okay. All right. All right. So is there any further discussion on this to be tabled?
So the Boston actually has you listed, and a really nice picture, I might add, as a 2026 resident. So that's a bummer that they can't send her degree certificate. Yeah.
I have one question for you. The reason you denied it was because it was an orthodontic residency. It really doesn't matter at this point if you get the conference because you're not approving the residencies if they're specialties. So I'm confused on whether it matters if she does get the diploma. It's not going to matter. It's just going to declare that she's completed the residency program.
I was going to bring that up because what Ed was saying in the past, if you table it, as Leaf was saying, then does that send a signal that if all the ducks are in the row, then we're all on board? This board is not divided, but don't know how to say it, there's difference of opinion as far as if a specialty residency from a CODA would satisfy that licensing, or if that CODA residency has to be strictly in a general dentistry standpoint. So I personally can't say if we table this, that's going to be a certainty that if all the ducks are in a row, you come back and you're going to be granted that license based on the board's opinion in the past and how we interpret that statute. I just think that needs to be very clear to the candidate and the attorney.
My advice at this time is that the only board members who should say yes to the tabling motion should be those who or either at yes, they would do this in the event that this is completed, or that they feel that there's any chance that they could be persuaded to yes. If those things are not in, if you're a hard no on those things, it doesn't make any sense to go along with the tabling motion. That would kind of give you your, that would kind of signal to the party exactly where we're at. And if the tabling motion fails, then we talk about the next step of the process.
And I personally think that is appropriate. I can't say for sure. Draw my second.
I would note for the board, and I push back gently against the AG's counsel here in the sense that the tabling motion allows the board to take up additional information based upon the presentation here, as well as the concerns voiced by those individuals on the board who may not be willing to vote yes at this time. So it would present us an opportunity not just to get that BU degree, to circle back to some of the concerns regarding conferral. And so I do believe that there's a more expansive read of the tabling, and I would posit that for the board's consideration.
And when we might be talking past each other, I don't even know that we necessarily would disagree. My entire stance is don't vote for it if you think it's truly doomed and you're a hard no. And that's really my only stance. If you think there's any path to yes, then yes, support the table. It'd be fine.
So we had a motion, but Robert withdrew his second. So is there another second to the motion for the table, to table it? All right. So all those in favor of allowing this to be tabled, raise your hand. And those that are opposed, raise your hand. Of it, 5-3. Wait. Oh, wait.
Five also is a majority anyway, so.
Okay.
Yeah, that vote is.
All right. So the motion carries that it has been tabled.
Thank you, members.
Let's put this in. All right.
I think we need to revisit that particular thing about specialty license and license in general.
I think that's a very valid point. I think if we investigate a specialty license, I know Annette and I've talked about that. I've had conversation with that. It would be beneficial for not only the applicant or the practitioner, but also many of the consumers and citizens of the state. Because there's a dire need for certain specialties on the outscope, whether it be oral surgeons, perio, whatnot. You've got specialists such as surgeons coming out of the military, retiring, that want to extend their career, and that'd be a very valuable asset to our patients and consumers if they were able to do that. I understand there's concern. This is my opinion. I understand there's a concern at granting a license for a person who's going to do nothing but say oral surgery for 20, 30 years, and then you open it up to them doing orals, come back and do general dentistry, and that can be danger to our patients. Understand that we present a license to general dentists coming out of IU. They go out and practice for 35 years doing surgery. There's no guarantee after 35 years they go back and do a DO prep or something. It's kind of the same thing. So I think a specialty license, investigating that possibility would be very beneficial to the board and basically the citizens and the consumers and the patients.
I agree with that. The only trouble is it's going to take years and law changes to do so.
And I understand that. So that's why I say that that's investigating it so we don't prolong it, because it's obviously a problem. you have very highly qualified people out there that can come and help. And we're denying that possibility based on that.
This just further proves my point that we should give them a dental license. We have the ability to give these people like Polito at the school a dental license. And you guys have all denied it. He meets all the requirements. She meets, you know, if she graduates from her program, all the requirements. And you've chosen to interpret the law as it needs to be general dentistry. The law does not say that. It says that it has to be a 2-year clinical program from an accredited institution. It doesn't even say accredited program. So we're fine under law to be approving these people as it stands. It's just the interpretation that several people have taken that it needs to be general dentistry accredited CODA, but the law doesn't say that.
Agree with that because the law says very clearly in 6, and it has A, B, and C. And it says they have to complete a clinical training program in at least 2 years in one of the following. The first one is something that is equal to getting your DDS or DMD, an accredited institution that reasonably ensures a level of competency equal to that of graduates of accredited dental colleges. Okay, so that's their avenue of pathway of coming in and getting their DDS by going into the dental school and getting that, and there's pathways for that. That's how it reads, because you have to be competency equal to graduates of a dental college. That's learning all of dentistry. The second one's the general practice residency, and the third one is the general dentistry program of advanced education. So that's how it reads.
And I agree with that on that. I interpret it that way. In respect to Matt, I do. That's exactly how I interpret it. That's why I propose that we grant a special, or we look into the process of doing a specialty license to allow these individuals to come in who want to practice, whether it be ortho, surgery, or whatnot. It gives them a pathway, and it will eliminate a lot of the confusion or the divisiveness that this board has going into the future. And I know it's a long process, but I think that if it's something that we need, that we think it's necessary, I think we need to start that process now instead of debating over it for the next 2 years, and it just prolongs that. That's my point.
So I've thought about this a lot, and I've thought about a lot of my colleagues that are in this situation. And they are very gifted and talented specialists. They may be oral surgeons, they may be periodontists, they may be endodontists, they may be orthodontists. They are never going to turn around and do a DO resin. They don't even have the equipment in their practices to do those things. And I think we're doing a gross disservice to not grant licenses. And I know that is a total light bulb flip for me, but I have talked to a lot of my colleagues, and the individuals that are capable of coming to the United States and completing one of these CODA accredited programs, because those are not easy programs to get into. I think we're doing the wrong thing. And if you look back in our minutes, we have granted licenses back in 2022. And then we started doing something different. So we have not been consistent.
I'll add to that because I know of clinical and pros faculty at the school that have actually done this channel and they've got their license. So we're not consistent. The boards are not consistent from what happened years ago to what's going on now. So I just think we need to review it.
Is this an item that you guys would like to make to put on our agenda for the next meeting? And this will give us time for everybody to go home and collect their thoughts. And we can put that under discussion next time where we could kind of hash out some points, but it'll give everybody time to research. And then maybe by doing that, we can maybe come with a better can be more consistent. Like you said, maybe the board can come into an agreement that, this is how we interpret it, and then moving forward, it might be a little easier, but at least we could have some better discussion. Would that be okay for everyone? To
Yeah.
place that on the agenda? Can we do that, Cindy, for our next meeting? We'll put that under discussion. So if everybody gives you a couple months to Google away, Google till your hearts, or bring back your Judge Judy points, to convince. Mhm.
Okay, so I understand Twyla and I understand Ed, and on Ed, on that third option, I'd forgotten that third option specifically mentions general dentistry, and it does. The only thing about the specialty license that concerns me is we haven't had this discussion for a long, long time, and I think a lot of the board members are gone that were involved in it, but it was kind of a specialty license. Does that raise the bar for general dentists? So general dentists out in rural areas doing extra oral surgery and doing extra specialty things, I guess my only caveat is, does that raise the bar that they have to be a specialty level on that stuff?
Yeah, I'll just get on the floor. I'm really against specialty licenses. And for clarity with Leaf, there's no statutory authority for us to create specialty licenses, right? There would need to be some statute changes first. Okay.
All right, we're going to move on to our next appearance, which will be Oliver Flores, LDH. Okay, we'll do this after. All right. You are before us because you answered yes to questions 3, 4, 5, and 6 on your application. So it looks like in regards to that, there were a few charges of speeding. You had a theft charge that was dismissed, a battery resulting in bodily injury, which was dismissed, disorderly conduct, resisting law enforcement, operating a vehicle while intoxicated, and you also have an order of protection that was filed and granted. Looks like your jail sentence was suspended for the 180 days. 363 days probation, which was signed in January of 2025, that you completed this past January 27th. You still have your no contact order in effect, and you've completed 5 sessions with a counselor in regards to anger management and training and things. So do you want to give us a little background? You have quite a bit of charges here. If it's green, yeah. And then
Okay, now
speak
it's
into
working.
it.
Okay, so I just wanted to clarify that the no contact order that ended in January, upon my probation ending. So essentially, to start it all out with the DUI and the resisting arrest, I had some issues with drinking after my mom had passed away when I was 19 in 2020, and I turned 21, and I just turned to alcohol, and it led me in the wrong decisions. And in this particular instance, I didn't even know that I had fled from the police, just to give you an example of how much I had drank that night. So I did an 18th month. I got into diversion for that. Both of those charges were dismissed, and I did an 18th month program where I got off a couple months early for good behavior. And then going forward, I ended up getting into a slight altercation with one of my ex-girlfriends. She wasn't physically harmed, but regardless of the point, something had happened that put her in fear, that wanted her to go to the police. So that's where the battery and the theft came from. And then those were pled down to just disorderly conduct for that, which I served a year of probation for.
Questions that the board have?
I'm sorry.
Go ahead.
I wanted to add another thing. All of these instances I have really learned from. It's nothing that I'm proud of. It was really the lowest point in my life, and I had to learn a lot from it. And since that last arrest, I completely stopped drinking. I'm about to be 2 years sober. I've been going to therapy since my last arrest in October 2024, and I'm continuing therapy, and everything so far is really going good for me. And this is actually my second degree. I got a degree in anthropology in 2023 with a international studies certificate, and then I came to dental hygiene because it was something that really interested me. And just over the course of the past year of being able to see patients, and it's just something that I really loved doing. It was a passion for me, and I was able to help people. And I don't know, there's just been a lot of hurdles that I've had to jump through. And like I said, I'm not happy of the things that show up on paper that don't look good, but ultimately it's made me who I am, and I'm proud of who I am now. And
Are you currently attending any, AA meetings? Do you do that?
I haven't been to an AA meeting since my 5-month coin. I plan on going back, but it hasn't been as like helpful for me as it is other people. But I do go here and there. But therapy is an ongoing thing, just to discuss just general occurrences in life.
And have you had issues in the past with, alcohol? Have you been arrested before or had a DUI in the past?
Yes, my first arrest was for a DUI and then a felony resisting arrest, to which I was in a diversion program. That was alcohol related. And then the domestic incident, which led to a disorderly conduct plea, that was also alcohol related.
But that's these charges.
Yes.
I'm saying, other than these charges, have you had other DUIs?
Oh, no,
besides
sorry.
this one? Is this
No, ma'am.
one and
Yes.
done?
Yes.
So do you, what are your plans for working, providing we grant you a license?
So currently, right now, I have received I believe it's a PLN offer from Aspen Dental, where I'll be working one day a month on a Saturday, because I like their idea of bringing like practice to people. And then aside from that, I plan on finding another full-time position like Monday through Thursday or something. So essentially a Monday through Thursday and then a Saturday here and there or as needed.
So I just looked at your transcript. You had a 3.5 GPA with all this other stuff going on. That's pretty good.
Sometimes it's hard for me to see all the good things that I've done when, there's all of this stuff on paper. And it's also hard because, I had a 2.5-hour drive down here, and I'm just thinking like, I'm only here because I couldn't get my drinking together.
And
of course, other reasons, but
And first time pass on the 8X and the NBDHE, correct?
yes, ma'am.
Pretty good.
Two questions. I believe his criminal probation is all finished, from what I understand. And that's what you understand?
Yes, sir.
January
As of January.
27th of 2026.
Yeah. And then, you're still a very young individual, and I think you have a lot going for you. I just want to be confident that you have a good support system.
Yeah, I have been blessed with the family that I have been given. My 2 grandparents there, for example. Well, for my first degree, I got FAFSA paid for it completely. And then for my second degree, my grandparents were like, they just paid the tuition for me. And I've had a house over my head. I've had a car given to me, just helping like all avenues of my life. And I couldn't be here without them. And so they're a big support system. But a few years ago, like, I just hid alcohol from anybody, and then I would just get into things when I was alone, and just didn't lead to good decisions. So that's why I decided to quit.
Are they around you on a daily basis? Do you
Yeah.
live alone, or do you have?
I currently live with my grandmother and my grandpa. He's brain injured from an accident about 20 years ago, and I plan on moving out once I actually have some money. Because I've been working part-time at Target for the past couple of years while I've been in school. It was just anthropology, but what really struck my interest, I think, was biocultural anthropology. I got to go on 2 study abroads too during my anthropology degree to Mexico and to Costa Rica. Yes, with IU South Bend.
I would support a motion to grant, his license again. I would encourage him to, find a regular support system outside, whether it be an online therapy or a therapist when you are fully employed and have some more money to do so. Because I think it's going to be, you have a lot in your past and some trauma there that I think following up with some support in another way is going to be helpful for you.
Yes.
You're seconding the motion, Robert? All right, so there is a motion to grant licensure. All those in favor say aye. Aye. Anyone deny? License has been granted. So I guess you hear from the board our concerns. One of the things, Twyla being our hygiene representative, is your stress levels is just started. So please take what Dr. Salmon said to heart, to get a really good support system there, that you've got some people to help you so that you don't turn again to drinking. That you have some support system there, because once you start working, that stress level it is going to increase and stuff. And again, hopefully this is one and done, and you seem like you're going in the right direction. And so we want to encourage you that. But as he said, make sure that there are people out there that if you just slip a little bit, you've got somebody there that's going to really help smack you back into place and get you going.
Yeah, because I was just telling my family that, like, as I was telling you, that although it's not ideal for criminal history, like, sometimes people learn from it and they make you who you are. And I've seen the lowest parts of my life, and now I'm ready to see the best parts. And I just wanted to extend my courtesy to all of you for having me down here and listening to me and giving me a second chance.
Good. Well, we wish you nothing but the best.
Thank you.
And please stay on that positive path. You've got a long way to go in your career. So it sounds like you're in the right direction. Keep moving forward.
Okay. Thank you all. Have a great day.
So even though you graduated, your faculty at IU South Bend, I know a lot of them.
Oh, yeah, they're great.
So you stay in contact with them. If you need them, you reach out to them, because even though you're graduate, you were still part of that family.
Yeah.
Okay?
Perfect. Are you alumni? Sorry? Oh, gotcha. Oh, my grandparents. Yeah, I won't. Yeah,
At least for the free home cooked meals. I mean, come on.
Well, everybody's got to stop getting older. That's the problem.
All right. Congratulations.
Thank you all.
Best of luck.
Have a great day. Good luck. Thank you.
Our next appearance is with Maya Hun. Hi. So you are appearing before us because you've answered yes to a couple questions also on your applications, questions 3, 5, and 6. So it looks like in March 29th of 2025, you operated a vehicle while intoxicated with a level of 0.08 or more. You are on 1 year's probation, which is scheduled to be completed this December. So you still have 4 more months. You've done 40 hours of community service that you completed this past January. Your driver's license was suspended. It's been reinstated in December, and you completed an alcohol and a substance abuse evaluation through Bowen Health in Auburn, Indiana, and you voluntarily enrolled in Living in Balance program that you completed August of last year. So do you want to give us a little background of the details?
Yes, so back in March 29th, 2025, I was with some friends and I made a poor decision to drive, and I should not have gotten behind the wheel and drove. And I've learned a lot since that incident happened. And when it happened, I've always grown up. I've never have been a big drinker. I've always grown up, my parents, with seeing them drink every once in a while. It was something that I never wanted to get into, and I didn't know what my limits were. So I made a poor decision, and it's been a heavy weight on me going through school, but I still managed to keep good grades in school and focus on that because that was my priority. And I made the mistake. But moving forward, with everything that happened up there, the process was a little slow. So it started in March, and I didn't go to court until everything was concluded in December. So in the meantime, before the case was open, I chose to enroll in the Living and Balance program through Bowen Health in Auburn, Indiana, just to show that I want to move forward with the mistake that I made and just fix those mistakes. And then my license was suspended, like we talked about, but it was reinstated in this past December. And then I just graduated from the IU Fort Wayne Dental Hygiene Program this past May of 2026. So.
Questions that the board has for Maya?
So what are your plans moving forward?
So currently, I started working at Salis Research in Fort Wayne back in August of 2024. And then I worked there part-time for a study that they had going on there. And then this last May of 2025, I started working there as a summer intern. And then through school, I was also working there as well, part-time and taking my classes. And currently, I have a full-time position there, and I plan to work there for the future once I get my license. But right now, I'm working there currently.
What's your support system like?
I got married in November of 2024, so I have my husband, and then both of my parents live about 20 minutes away from us, so I have them, and then my husband's parents as well have been a great support system for us, and then we are involved in a church in Auburn, so we have our church as well.
Okay. Well, it looks like you were a solid student,
I-
did a really good job, so yeah. Yeah.
It was a lot to focus on school with the burden of this incident. It definitely weighed on me every single day. So focusing on school was definitely a priority that I was able to maintain.
You have probation ongoing until December 12th, 26, is that right?
Yes, that is correct. Yep,
Okay.
a non-reporting probation. Yep.
Perfect, okay.
I make a motion to grant licensure on probation until her criminal probation is up.
Any further discussion?
By the way, that's just a normal thing. If you're on probation, it'll
Okay.
be on probation until the criminal probation is up, and then we'll explain that to you.
Okay, so licensure would happen once.
Yeah, he'll explain it.
Yeah, you, it would come on probation. You should be advised that it will not lift automatically. You need to let the board know that you are now done with criminal probation and that you would like your license taken off of probation. If you don't take any action to get it lifted, it will stay there forever. So the board doesn't want that. The board would prefer to take somebody off of probation if they don't think that it's a good thing anymore. So just make sure that you're staying on top of that. And when your criminal probation is over, let us know promptly.
So the motion, oh, go ahead, Matt.
No, I was just gonna tell her, you can practice, there's, no, yeah.
Okay.
So,
So I'll be able to get my license active. Okay, and when would that time frame be, or what does that look like?
Let's take a vote first.
Okay.
Let's vote first. We were jumping the gun here before we do it. So the motion is to grant with her being on probation until, with the stipulation until she finishes her criminal probation. And all those in favor say aye. Aye. Any opposed?
So the license will say, rather than active, which is a free and clear license, it will say probation. With that said, the board, when they grant licenses on probation, have the option to put restrictions on your practice. They did not do that. It is purely the label of probation, which is basically to say, if you have more trouble during this probationary period, that's going to be a bad thing. And they're going to take that into consideration as more than they just would if it was a first thing. So that's the status. Nothing prevents you from doing everything else the hygienist does. It's just the license status that you have to be encumbered with at this time.
So it's been granted. So again, you want to be perfectly honest with your employer. So as you're seeking employment and things like that, you want to let them know. And as attorney told you, we've only stipulated with your criminal. We've added no other additional restrictions on there. So if you finish, we meet every other month, even months. So if you finish this in December, you have to apply to withdraw from probation. And you could do that as soon as you have finished in December, and then you will be put on our agenda for our February meeting. And that would be, if you were here this morning, that was like how we did the administrative hearings, where you come before us, say that you've completed, you'll submit your criminal probation that's been completed, you'll submit all that paperwork to you, and then we will vote on whether to remove your probation from you. So again, you want to do that as soon as possible. Since yours is so minimal, we've not added any additional CE or anything like that that we normally do. This is very, very simple. But like Attorney said, if you have to initiate it, and if you don't, it just stays on and on and on, and you don't want that on your record. You want that off as soon as possible.
You're gonna get an order in the mail and it's going to say granted on indefinite probation without right to petition for probation withdrawal until your criminal probation has been completed. And so it is specifying not just that it ends at that point, but that's when your right to ask for withdrawal kicks in.
And you will also receive a letter with that order that has some frequently asked questions with it, and I'll kind of walk you through the withdrawal process, how to submit that with the litigation law form that's online, and it'll also have contact info if you have questions.
Okay.
So you'll receive that order and that letter via email with your email on file.
Do you have any questions for us?
Yes, I know the last step in the licensing process, the law exam, before I get my license, when would that come, or what does that process look like?
You can go online.
The law exam will be emailed to you and you'll return it to us by email. So that'll be sent to you probably today. Cause I am processing those as we go through those. As far as getting your license specifically, we do have to wait till the order is issued in order for you to get your license.
Okay. Do you know a time frame on that, or what that would look like? If not, that's okay.
I can't give you a definite time frame, but we hope to probably have it within the next 30 to 60 days.
Okay, sounds good.
All right. Good luck to you.
Thank you, guys. I appreciate
You're
everything and for listening to me. Thank you. Thank you.
Our last personal appearance is Dr. Mohammed Noorudin. Hi, all right, so you are appearing before us because of you failed the national board 3 times, part 1 and part 2 we have on here. So do you want to give us a little background?
Yes, initially when I was starting to prepare for the national boards, I was practicing back home. It's not like an excuse, but it's a combination of a couple of things. I used to come here for just taking the boards, preparing, practicing, and managing all that at the same time, including the format of the national boards at that time was new to me. I was still working around it. So that's why I had one first attempt on the part 1 part of it, but I cleared it in the second one. Part 2, like I said, initially I was coming on visit, taking an exam, so I had like a certain limited period of time when I could take the exam and go back. So I rushed into the first 2 attempts without analyzing why I failed that. And same thing happened. I went back, prepared, did the same preparation I did for the first exam. First time I took the part 2 exam and didn't realize what I was failing at, and came back and did it, didn't clear. But next time I came here, I moved here, so I had time to realize what was going on. I figured out what was going wrong in the exam. The part 2 exam was like, it's 2-day exam. The second day exam was the thing I was not getting it. And I realized that it was because I didn't have experience of how clinical analysis was done in the States. So I started shadowing dentists who work here, figured out what was going wrong, how I was not looking at the cases that I was supposed to. And then the next time I took it, I passed the exam. And after that, I applied for schools, got into Indiana University, did my graduation, passed all the exams, everything in one go, including the 8 exports, all part of it I passed in the first attempt.
All right, questions that the board has?
Individual. So you did 2 years at IU, but
Yes.
then 2 years where there was a previous 2 years. Did you do all 4 years at IU?
No, I did the IDP program, International Dentist Program. It's 2.5 years.
Okay, I was having a hard time interpreting that. Okay, thank you.
Additional questions? There a motion?
I'll give my take and then make a motion. In my opinion, so in July, we were given more freedom to find exception to the three-strike rule and statute. And so in my opinion, when assessing his resume and transcripts and everything, I think he is a good exception to the three-strike rule to make. He took all the failures that he had related to the board exams came before he started in the IDP program, when he was, I assume, learning a new language. Obviously, he was in the middle of traveling to and from his home country to the States. So there's, in my mind, plenty of reason for a couple failures. Once he got into the IDP program, I think his GPA was a 3.8. He passed all the clinical boards and dental school boards on the first attempt. And he meets the requirements of the clinical training. So I would motion to approve licensure for this candidate.
Can you make it, because I still had discussion. Okay. Did you ever pass the national boards part 1 or part 2?
Yes, I passed.
You passed them both?
Yes.
You passed both boards?
Both years.
Okay. It just took you more than 3 times
Only
to
for
do-
part 2.
for part 2?
Yes.
Okay, because I was looking here and I couldn't see on the screen that he actually passed part 2. So he did pass part 2.
Right.
It just took you more than
More
3
than 3
times to do.
Yeah, I passed it on.
Okay,
fourth.
that answered my question.
I'm going to second the motion for approval.
Is there any further discussion? Motion is to grant licensure. All those in favor, say aye. And oppose. Is it 9 yeses? Twyla, are you a yes? Discretion of the board.
I should say. He failed. The new statute reads that if an applicant fails the board 3 times, it just says board or approved boards by whatever, then he may apply and license may still be approved it's at the discretion of the board at that. That's all it says. So it's a discretion. This individual has failed part 2 of the national boards, not the clinical boards, part 2. But he did pass part 2 on his 4th try. He's here presenting what happened, how he's done the remedy. So now it's at the discretion of the board if we approve that. Does that help? Okay.
Yeah, it's subsection B says the board may establish additional requirements for an applicant who has failed the examination at least 3 times and must complete any additional requirements before the applicant may take the examination again. That is not a necessary step. That is an option.
So Matt, you're just free and clear with
My motion was not to include any new things. It's to approve.
restrictions.
It wouldn't. Probation is only available if there's disciplinary background anyway, and not a qualifications question.
And Leaf, you just spoke the new kind of language that was put in? Is that what you just spoke?
Yes.
Okay.
All right, it has been granted then.
Thank you so much.
Thank
Thank
you.
you. I appreciate it.
So somebody,
if there's something else to it.
Well, that's true. Somebody came here before the board, because Shane talked to me about it. Somebody came before the board and they failed the clinical board 3 times. And then they still tried to apply for a license. I don't think that, my perception is we're going to grant a license unless they've maybe passed it on a 4th time. So maybe they failed it 3 times for whatever reasons, maybe there could have been extenuating circumstances, death in the family or whatnot, and then they went and retook that exam, they passed. That's at discretion of the board. Now, there's underwriting things per the language, from my understanding, what Leaf was saying, that maybe that they did do that, but there's a probation, there's something else going on, then you could put restrictions or remedial processes on that. Or but maybe they've had three failures, and they come to us, they says, no, here's some remedial. You need to, with all your extenuating circumstances, you need to go take the board again. We could advise them to do that.
Okay. We're going to go back a little bit to personal appearances under probation with Dr. Downey. How are you today?
I'm good.
Good.
I apologize to the board for my confusion. I looked at the agenda posted online and didn't see my name. So, and I believe I saw people appear on Zoom before. And so I was at the office sitting on Zoom. And as soon as I heard that that wasn't a thing, I came over here. So
Thank you so
I
very much.
apologize.
No.
For clarity on certain things, it can be, but for the personal appearance, they can set terms, something like this. So you didn't imagine that. And if you see a future meeting where that happens, nothing changed. It's just didn't apply here.
I understand.
All righty. So do you want to give us a little background on what you've been doing and how you've been doing?
Yeah, I would say that for the most part, there hasn't been much change since my last appearance. I still work as a dentist on Thursdays and Fridays with Dr. Kevin Cash on Madison Avenue. And I just started another job working on Tuesdays and Wednesdays on Meridian with Dr. Jack Summerlin. Mondays I have open. I'm cutting back to, I was doing sub hygiene Monday through Wednesdays, but I've decided to give myself an extra day just to kind of recoup. But I'm pretty happy that I have this second job now so that I'm not running all over the place with different hours and doctors and expectations. So, and I finally get to do more of what I trained for. So, things have been pretty consistent at home with time with my daughter. AA meetings, still 3 to 4 meetings a week. I still meet with my sponsor. I still do weekly therapy. I meet with my psychiatrist regularly. And I'm now I had my first meeting with Ann Kelly with the IDA taking over for Candace. And so we had a really good 45-minute long conversation the other day. She's very kind. I'm excited to be working with her. I think the only big change, my cat passed away last Thursday. She was with me for 14 years. She was my best friend, went through a lot with me. But we're getting through that. And if that's really the worst, then I think I can survive anything.
Good. Well, it seems like the letters that Candace submitted on your behalf were nothing but positive. She said you were completing the program and that they agreed with her and the therapist that you could return to work for 4 days a week, and that you were following through with your regular sessions and support group and things like that. So it seems like you've been following all of that. Does the board have any questions for Dr. Downing?
I don't have any questions, but I think this is one of the first times I've ever seen you smile in front of us. You look great. You look
Thank you.
so much healthier.
Thank
So
you.
this is great.
I have a lot of anxiety, especially with public speaking. So that's probably why I look pretty tense most of the time.
Well, you look great today, and
You.
it sounds like things are going good. So this really makes us feel good.
Thank you. I appreciate it.
Really sorry about the cat, by the way. As a cat owner myself, that is a truly, like, I really don't look forward to that, so.
I appreciate that. She will be very missed.
All right, looks like you appear before us quarterly, so your next appearance will probably be our December meeting then.
December.
And
Okay.
you will have to be live.
Okay.
Yeah, we don't allow the Zoom ones, you can just hear us, but we can't communicate to you.
I realize
So,
that. Yes.
Yeah, so in December, we hope to see you again with another great big smile.
I will be here.
All right, thank you, enjoy
Thank
your
you
day.
so much. Thank you.
It says the same thing as I said.
Oh, okay.
No, it's over here.
Oh, okay. I was like, thank you. Do you guys want to take a 5-minute break? Okay, 5 minutes. It doesn't whack. It's dented. Yeah, I do. All right, we're gonna go just out of order here a little bit. Oh, did you start the recording? Okay, all right. And Dr. Evan, we're gonna let you come on up. So we're gonna do this before we go into our applications for review.
Can we have, then Amy come and talk about the rules?
Amy, the rules, okay.
She has one role.
Okay, we'll let her do that too. Okay. All right. Is your microphone on? Is it green?
It is on, yes.
Perfect. All right. We'll let you present what you have for us.
All right. Well, thank you for allowing me to come and address the board. I would just like to say I'm speaking really on no official direction of anyone other than the fact that I was the IDA Workforce Task Force Chair for the past 2 years in developing some pathways and some strategies to address a workforce shortage. And then to that end, was tasked with the direction of creating a curriculum for a new position called an oral preventative assistant. I'm sure you've probably heard of this position before. We were assigned by the previous IDA president a task force with members spread throughout the state, including a representative from the dental assisting community and the dental hygiene community. And then over the course of about approximately 9 months, we gathered data points and information from several locations, other states, other programs currently utilizing or developing such a program, and then created a conglomerated and a unique certification pathway for the state of Indiana. That curriculum was really the extent of where my task force was supposed to go, just to come up with a curriculum. At that point, there are several other hurdles to come afterwards. So it was my intention today to come before you to seek some board consult about the curriculum itself and the direction of such a proposal and what potential input you might offer moving forward as we continue to explore options. I would say in general, I'm an extremely strong advocate for dental hygiene. My
daughter, my oldest daughter, is currently enrolled at her first year at IUFW as a dental hygienist, and I think that the expectation of that profession is strong. But I would also recognize that through a combination of factors, there is a clear and pressing need amongst the state to increase our workforce. Obviously, that can be accomplished through multiple pathways, and I think increasing cohort size where appropriate at traditional hygiene programs is preferred. But there are financial and logistical constraints that can sometimes not bring that to scale. So by having another alternative pathway, you might be able to address some of those issues more nimbly. I don't have access to the entire curriculum. It's about 350 pages. It's mostly presented through an online situation. If you're familiar with the radiology program, you would liken it to that. There can be a printed version, but it's an online version. I'm comfortable discussing at any link that you might have questions, and just look forward to your input. Well, the proposed curriculum that was developed through our task force is modeled after an on-the-job training. So the initial instruction would happen by the licensed dentist in the facility where the assistant is employed. So it is a dentist-driven program. In other words, it's not something that any person can apply for. You are sponsored by your dentist, and you have to meet certain criteria. There are certain restrictions, barriers, so to speak. For example, a prerequisite includes either one of two pathways. You can have an education pathway where you are a CODA accredited graduate of a dental assisting program. Or you can have an experience pathway where you have 3 years of verifiable dental assistance experience within the last 5-year time frame, or the equivalent of 4,500 full-time hours that is verified by your dentist. Once those pathways are sort of triggered, then there's prerequisites that occur. You have to have your radiology license. You have to have your coronal polishing certificate. You have to complete your CPR BLS. There's also a caries prevention, advanced placement credits that are required prior to being admitted into the program. But ultimately, to answer your question, it's administered by the dentist.
So if the dentists are doing the training, who is evaluating that the dentists are qualified to do the training?
Well, I would think that would be the responsibility of the board. I mean, don't you guys do that? I don't know.
But we don't have jurisdiction over assistants because they're not licensed.
No,
So-
I guess what I meant to say, maybe restate your question. I don't think I understand.
Well, you were saying that it's the dentists that are training these applicants. So what are how do we know that that dentist is qualified to be doing, are they just saying, here, go online? What are the
Okay,
what
I
are the
see your point.
restrictions or what are the requirements for the dentist?
Included in the curriculum, and in the same way with the radiology portion, there is an educational component that's sort of like a train the trainer. It gives the dentist the benchmark things that are expected of them. But I think ultimately it's probably this, and I would ask how it's done in the education world, but the licensed dentist is probably given the protocols by the university and say, these are the the benchmarks that we're grading you on. And then that dentist is then tasked to evaluate that. I could be wrong, but that's the way I interpret it to happen. It doesn't have to be. I think it could be run through a university as a secondary option, but I think my curriculum was intended to be done directly in private practice offices. It could also be done as a group model. So at this point, there's really no specific tasks that are technically legal. So all of this is just some future debate depending on but as intended, the treatment is supposed to be addressing a 1110 hygiene code. So a healthy gingiva, supragingival cleaning and polishing. No subgingival access, direct supervision of the dentist. So what I mean to say by that is that the dentist would evaluate the patient, determine their periodontal status. If deemed a healthy periodontal patient, then the OPA would proceed with the routine prophylaxis, and then as normal, the dentist would come in for their periodic exam. Well, I think no, the training would include scaling techniques, supragingival scaling techniques. I would think there would be no curette training, as those are instrumentations that are more designed for subgingival treatment, but a universal anterior posterior scaler, much like I'm sure any one of you have done in a pinch where your hygienist is not there. You go in and you will do a prophy if you need to, and so you would utilize those supragingival instruments and remove the plaque. And
I think you'd have to come up with a different code other than 1110, because I don't think I've ever done an 1110 code without going subgingivally. Because you got to clean underneath the free gingival margin.
Just a matter of, I guess, legislative process, and Leaf, correct me if I'm wrong, but if this, in the past, when we've added duties, delegatable duties to dental assistants in statute, this is how it's worded. This goes for coronal polishing and fluoride. A dental assistant who has completed a board-approved curriculum may apply, fluoride or may polish coronal teeth. That's what's written into statute. So the question to Evan, Dr. Heupel, would be, are you intending to model legislative language like that?
Well, I definitely support the idea. However, I don't have any direct representation with the Governmental Affairs Committee or with anyone that would be developing that legislative language. But I'd like the idea to be similar to that, where it's board, sort of board approved.
So let's just, I guess, assume for a second that it is, because that's kind of precedent, is that it then flips it on the board and the curriculum has to be approved by the board. At that point, all due respect to Dr. Heupel, it's up to us how we want to define that curriculum. So if you want it code approved, if you want him to take board exams, if you want him to do whatever, he's put together one program, but if the statute's written to give board authority on what the curriculum is, it's completely up to us how we would want to define those requirements. So part of this, I think, from his perspective, is what would we want to see if it is up to the administrative code, and what are we able to tell him, Leaf, legally, or are we overstepping, or there's a lot of assumptions right now.
Yeah, overstepping if you do what?
I guess give him feedback on what we would want curriculum to look like for said program.
For a CE or?
In order for us to feel you know, so if legislation passes that says OPAs can supragingival scale and the curriculum has to be approved by the Board of Dentistry, then it gives us legislative authority to create rules around this position. Who's able to, you know, do it, how many hours they need, what exams they need to take. And we would have a long list of rules under this new position on what's required. Whether, you know, they've essentially created an on-job trained type of program. Is that something that as board members, we would approve, or would we require candidates to graduate from a code accredited school, take a board exam? That all
If I'm
becomes up to us,
understanding you-
right?
If I'm understanding you correctly, and you're talking about hypothetical future legislation, then
Right.
then yeah, you probably shouldn't get too far out over your skis saying if this, then, because yeah, you just don't know exactly what the law will look like. The law can turn on a word very materially. So, yeah, I would say it's premature, not that it couldn't eventually be appropriate, but.
I don't think, and correct me if I'm wrong, it's the board's place to put what goes to legislation and try and set legislation. Am I correct on that, Leaf?
That's correct.
Okay,
I mean,
so it's more appropriate that what legislation passes comes to us, and then we set rules to accommodate that. Am I correct on that? That's
correct.
what I thought. So I don't think my personal opinion, I don't think it's appropriate for us to sit here and say, you need to go here, here, here and present this legislation. We want to write this law. I don't think that's within our purview. Is it correct?
No, I mean,
We can give input as far as what we've done in the past, as far as rules and things like that for guidance, but basically what legislation does, it sets, and then we enact that legislation. That's my point. Thank you.
that's the safest way to stay away from blurring the lines of, lobbying or political.
Because I don't think it's wise to blur the lines between the board and legislation.
I think input is okay, and I wouldn't mind Twyla's input on what you believe a good exam of what type of knowledge test would you want at the end of said training to think that the public would be safe?
I don't think there is one that exists, number one. And I think the thing that concerns me about this is there are very few patients that are going to fall under that healthy category that would only require supragingival scaling. I mean, there's a lot of patients that are adult prophy patients that have no bone loss and have subgingival calculus. And if they are only restricted to scaling above the gingival margin, you're leaving that subgingival calculus. And that's doing a disservice to the patient. And that worries me down the road. So I don't know if this is really the solution. And then the other thing that, how do dental assistants feel about this? They have a lot of duties in a dental practice. Do they want another additional duty put on their plate? Because they do a lot of things that I have no clue how to do. And I'm not sure that they want another job tasked to them, because I sure don't know how to make a temporary crown. So I don't know how they feel about this. So that's just something to think about.
Yeah,
Dr. Heupel, is with the assistants, it's my understanding that it's a totally voluntary
That's accurate, yes. In fact, it's voluntary even for the dentist to participate. So in the same way that statute exists for my office to utilize coronal polishing, I don't have any dental assistants that are certified in that. I didn't find that to be a valuable addition to my personal practice. And there might be dentists that would say this process does not fit me at all. My my practice is very heavily, periodontal patients, and I wouldn't benefit from this. So in that sense, the flexibility of that is valid. I think it's those offices, maybe in a more rural setting, that are having a very difficult time finding appropriate staffing. And then, you think about the idea of do no harm, and obviously, as the state board, you're tasked with protecting Hoosiers and keeping everyone safe. And at some point, I think it's valuable to weigh the juxtaposition of understaffed and underserved Hoosiers and what that does periodontally and from a bone standpoint, the risk of that long term, if they were to, develop bone loss, which is not repairable. It's without advanced periodontal therapies, you can get some grafting, but in general, that's a permanent damage to their health versus the potential negative outcome from a supragingival cleaning. I can reference a pilot program that's been taking place in Missouri where they've had 1,600 tracked cases of this OPA being utilized, and there were 0 incidents of negative outcome resulting in patient harm. So not that that is not possible. Obviously, even the best dentist can inadvertently create patient harm, but the likelihood of harming citizens feels like it should at least be considered with the workforce shortage. As a personal aside note, I'm currently looking for a dental hygienist, and there are none. And my practice is in Carmel, Indiana, and fairly affluent community with a lot of benefits, and people enjoy to live there and would prefer to work there. So the demand is such where I'm basically pressured to offer $5 or $10 more an hour and just steal someone else's hygienist around the corner because there's no other choice. And that's fortunate for me that I have several offices around the corner that I can steal from, as terrible as that sounds. But if I'm practicing in a rural community where there are none, I don't know what those options are. And so cohort increasing size is certainly important, and recruiting, and I think it's valuable. This is a little bit over the skis, but it's valuable to note the dentist's role in this issue too. I mean, we have to be respectable business owners. We have to understand and treat our ancillary team as valuable members, and not all dentists do that. In some of the offices, these hygienists and assistants are very overworked and very underpaid. And that's shame on us. So this is not just a one-sided issue, but in general, the outcry is strong across the state, across the nation, to make some kinds of changes. And it feels like in this capacity, we've tried to create a controlled, trackable curriculum that models the same type of knowledge that they would be learning in a CODA approved setting specific to those limited functions. And then it would allow for at least some potential ease of that burden.
Any additional questions? Directions? Well, anything?
Do you have anything online to look at yet, or?
So yes, you could be, the curriculum could be made available for your review. There's nothing that's formal at this point. The curriculum is all sort of illegal because there's no statutory rule that says we can train these people in this capacity. So there's a section, and I forget, I don't have it pulled up directly in front of me, but the first 11 or 12 sections are basically dental assisting review type of sections. And then there's the last 4 or 5 sections, which are more future clinical and dentiform type training. So all of that training is written in the caveat that, you know, after an existing law change, then this bit of the training would take place. But yeah, you could be provided with access to that. It's currently being managed by the IDA. So that could be provided to the board if you were curious to peruse it. It's been under the last 3 months, it's been going through academic review through some professors at IUSD to give them some input from an academic standpoint, because admittedly, myself and the members of the task force are not academics, so we've never written curriculum before. So I think there were opportunities where feedback from them would say, you know, what's the standard or how are you doing that? So I would say the draft that's currently available is not necessarily a final draft. It's the version that we have right now. And then depending on how whatever future legislation would happen, then obviously it would be amended or modified to reflect that required legislation.
Build the airplane. Starting from the start.
Well, as an educator, I'd be happy to review it for you.
Yeah, perfect. That'd be great. I can forward that to you. I think I've got your email. So it would be beneficial to note that given the appropriate timing, there is not an immediate clarity about the direction of this in the upcoming legislative session. And again, I think maybe Shane could speak more to that as far as priorities of the timing of when all this might happen. It is an important step, but it's also an important step that needs its due diligence. And to your point about sort of that ambiguity and nebulous nature, there needs to be a clear direction. And so really the point of my conversation today is mostly just to bring it to your attention. It's something that we are considering and evaluating. We've developed this. Ultimately, from a board standpoint, there's a potential where your input would obviously be required to allow this procedure to happen. So that's the intention of today.
Anything else? All right, thank you so very much.
Thank you.
I think I see, is that Amy in the corner? All right. Oh, she was over there. We're going to let Amy come up also and do an update on the proposed administrative rules.
Good afternoon now, I guess, in the morning. I just want to clarify a couple of my comments earlier today. When those rules, as Leif instructed, you had already proceeded on voting for them and moving them forward through the rulemaking process. And additionally, we had that kind of already ready to go last year. So again, that is why they're moving a little bit quicker than your overhaul. Your overhaul is within the process currently. I think, Dr. Finley, you've been part of some conversations with our staff attorney where they're asking for additional clarification on certain pieces of that. As soon as we get those clarifications filled in within the document, they send us our approval letter and it goes through the public hearing process. So it is as close to the finish line right now as we can get it while we're waiting on OMB to give us the final approval to move forward. So that's where we are with the overhaul. I can appreciate that. And you can speak with your cosmetology board colleagues as well. They've gone through the same process and it took them 10 years to get their rules done. So sure.
I mean, everybody I've talked to, any attorney that's been around PLA, attorney generals on whatever, they're working on administrative code. They're like, administrative code's impossible. you need to get Indiana code, like group like the IDA or something, just to bring that stuff in. So that, I talked to Mike the other evening, our representative, my state representative, was in a county commission, started talking to him. He was like, yeah, he said, administrative code is like ridiculous. He said, you need to be working on Indiana code.
I would echo that. Well, I would echo that, but I also would say it is preferable from an agency's perspective for you all to get language, not you all, because you can't, as you just talked earlier, can't really get into the lobbying pieces of legislation, but your associations or other interested groups, if there is language to get into statute that is not necessarily language where your specific expertise is necessary. So fees is a great example, right? If we could have fees, general fees be in statute as opposed into administrative rule, then we don't have to go through those rule processes. It's just in statute, right? Where your expertise is needed, administrative code makes a lot of sense. And having your ability to craft those rules so they fit your profession and they fit what you need in order to properly license those in your profession. So I would echo that to some degree.
The original revision been revised.
Right. And that's one reason why I think I was here a few months ago and I said, once you agree to your final revision of the rules, we need it to be the final draft of the rules so we can proceed forward. So we don't have to modify the regulatory analyses as we're working with OMB to get those approved and that sort of thing. And also as what kind of happened today, in that once that's in that process, the only revisions that we can really do are based off of what public comments are, or we have to recall the rule and start all over. So those are just things to keep in mind. I wish the rule process was easier. I wish we were better equipped to handle it in the way that you all want us to. These are the realities of it. We're trying to do everything we can to push it forward because we want these off our plates as well. We're, to get them moving so that we can move on to other rules that we have to do, whether it's for you all or for someone else. So.
Well, I think future lawyer, I think the younger guys, gals need to understand that small revisions. Every couple of years with that.
And that's one thing we're looking at because every 5 years we have to submit for readoption of rules that are expiring. Now, we can't submit changes during those readoptions. You either have to readopt them as they are or repeal them. But we are trying to think of a way that we can maybe push up that process so that we're looking like a year out, a year and a half out of rules that are going to expire. And then if there are changes that we need to make, then we get those changes in the works prior to having to do just the readoption. So it is kind of those batch that you're kind of talking about, maybe in kind of a smaller thing. An overhaul is great. We're doing one with pharmacy as well, and we did one with cosmetology, but it does take a considerable amount of time. So.
Amy, are you going to touch base on the convictions of concern modifications?
Yeah.
Okay.
So we've been asked to look at all of the convictions of concern for all of our boards. One of the reasons why is that it's felt that the list is extremely broad. And I think what I've learned about it historically is there was purpose behind that, right? You wanted something broad. I think that you got some advice from advisory council prior to this, that you wanted that to be broad. So you had abilities within that and you weren't restricted on what specific felonies or other crimes that might be considered. The concern with that is that the language is pretty clear in that the criminal conviction must be directly related to the duties and responsibilities of the occupation or the profession. I think, and I've sat through and I've talked with Dr. Finley, I've gone through these and I can make justifications for a lot of them of how they affect the dental practice. I mean, you don't always think that maybe they do, but they could be, right? Like child abuse could be one. If you're a pediatric dentist, that's a problem, right? And that's something that you all should probably think about, whether or not you're issuing a license to someone who is going to be going into dental practice, particularly in the pediatric context. However, there are some that I think perhaps are stretching a little bit, right? Attending a fighting contest. How does that directly affect the dental practice, right? You can make an argument, I'm certain you could, but that's kind of where we are asking you to start thinking about. We don't have to do anything about it today. We're just kind of starting this process. Huh? Yeah. I mean, that makes sense for a veterinarian, right? But for a dentist, can you say that that translates? You probably could make the argument. I'm certain you could, but it's more of the basic argument, the basic connection to your dental practice. So again, we don't have to do anything about it today. I've kind of sent Dr. Finley kind of my highlights of ones that I think probably aren't necessarily directly referenced to the dental profession. And so we can work through that the next couple meetings. If you all want to take the look at those separately, see what you think, and come back with notes and thoughts about how we could potentially reduce that list. Yeah.
You know, some of those convictions of concern are going to be caught before they even get, you know, we do background checks before they can even get into school. So
right.
This could be like you're thinking afterwards.
Well, yes and no. So this list is used in two different ways, right? Part of it is used for those going into school to be able to petition you all and say, hey, I have this. Is this going to bar me from licensure? And I think after talking to Dr. Finley, you've had maybe one case that's come before you, but you didn't necessarily make a definitive choice one way or the other. And I would argue that's pretty difficult to do at that stage anyway, right? Yeah. So this list really exists more for that opportunity of those pre-education licensure folks to even like engage in those sort of conversations to see if it's worth them going through the whole process. Again, like you said, at the school level, right? If they're already doing those background checks and having that information, they're going to probably run up against that first before they would even think about petitioning the board for some sort of information. Again, I also think this list can be used when you're doing kind of renewal and potentially reinstatement. I'd have to look at the language again to make sure if that's even possible, but you know, we don't do background checks on renewal. We don't do background checks on reinstatements. So the only way you really know is if that's disclosed. A lot of times that's caught through the application review process. Sometimes it's not. I'd have to check. I'm not exactly sure. Yeah, the statute is broad, is broader than the rule, obviously, but the rule, the part that we're mostly concerned about is that just full list and whether or not that's applicable. We have also discussed, and this would also be discussed with you, adding a little piece of language to kind of a coverall without being a coverall of other felonies that may or may not be included in this. The language in the statute is pretty clear that it can't be generic language, so we'd have to finagle that in a way that that meets the requirements of the statute, but those are the options as well. So something to think about moving forward.
So Robert, if you can probably send to the board that list so we can go over it, and that way.
Just remember, you can't reply to each other on that.
Okay.
Right.
So put that in your email. Do not, it's for informational purposes only.
Or Cindy, send it out.
Yeah.
Yeah.
Okay, thanks, Cindy. I didn't know if you had a copy of it. Yeah.
Yeah.
Sorry,
So
Amy,
there'll be
did
no discussion. Don't reply back and forth on the email. It's just for you guys to have, jot down your thoughts and stuff. And then, you know, maybe
In a
next
couple of
meeting, we
months,
can
we'll
go
come back,
through a
yeah.
couple of them, like Amy said, and say, this one can be eliminated, this one can be eliminated. That way it gives you a chance to go through it rather than just, yeah, we could do that. That'd be great.
Is this thought pattern correct that it would be part of the error doing that? Because you're gonna, if, for example, Cindy sees that they've been convicted of murder for within 5 years of that or whatever, we're gonna have to make, they're gonna be making first appearance. Any kind of felony they'll make.
Right, right. Yes. It's mostly for those pre-licensure folks, right? Those that are looking, yeah, that's the intent of the statute. And, but that list can be helpful for decision-making as well. Yeah. Yeah.
Amy, did you want to touch base on the MOU as
Yes.
well?
So the MOU and the contracts for the compliance officers both expire in December. Sorry, if that's reverberating. Expire at the end of this year. So we need to see if there are any terms within the MOU that need to be modified. I get the impression the MOU has kind of done what it's needed to do and that there aren't really any problems with the terms. Now, your selection of compliance officers, that's different. If you wanted to change compliance officers, renew your compliance officers, we don't have to do that. We don't have to make any changes to the MOU for those selections and things like that, but you will need to probably at least vote to renew if you're going to by the end of the year so we can get those contracts, so the AG's office can get those contracts rolling.
Is that again something that you can send to us in an email that we can review individually, the
The
contract?
MOU, yes. Yeah, I can have Cindy send that as well.
That'd be great. If
to
she can send
review.
that in the same email then, Cindy. So that, again, that would be not up for discussion, but just informational for you guys to have so that we can discuss that if there's anything.
Yeah,
we
we've got
wanna
some
change.
time to kind of dive into it. I just don't want it to be in December 15th and we're all getting ready to check out because of holidays and then we have to get this MOU completed. So just trying to bring it to your attention a few months in advance.
All right, we will put that on there. And then you said both of our, since we don't have copies of their contracts, both of our compliance officers expire also?
I
in
believe so.
December?
I don't have direct information with the contract, so you'll probably have to reach out to we could reach out to the Attorney General's office on that because they are the ones that own the contracts. So, but yeah, my understanding is that they both expire at the end of the year as well.
I can't remember for sure how that reads, but it was actually by the time the compliance officer got through all the hoops, having all the way to be an office of you know, by the time they actually got done with that, it was well into the year after the 2024
Mm-hmm.
you know, year.
Yeah, so
2025 January 1, then it expires.
yes, so the 2-year term.
So we need to probably find, what those dates are. Dates of actual hire.
That doesn't necessarily matter though, because the contracts will expire no matter what. Well, the contracts will expire. They're set to expire 12/31/26.
At that point in time.
So is that something you can get Cindy or do we have to-
You would probably want to do that prior. Yeah,
Can you get it?
yeah, just so that
December meeting,
I will defer to the contracting folks at the AG's office because I don't know how long their process will take for that.
I know, I just like skipping them. I was skipping that we had an October meeting. I was just like, this is gonna be really important. We need this for next meeting. And she's like, October? I'm like, yeah, but I already called today's meeting.
Do we know if
October."
both of them would want to do it again?
fall then.
And then also we talked about, there being 3. So we, who wants to do what territory? Obviously Paul is south, but is Mara gonna do middle or is she gonna do, if she's gonna renew or whatever? So, we have a position or we have the opportunity for another position. So again, we would need probably to discuss that on the October to reach out to any candidates. So if we've got to do contracts in December, that we've got that going so that we have 3 on board.
That's within our responsibility.
Yeah, it is.
Right.
And I would encourage you to sooner the better on selections and all of that. If we could get something done by October, great. Again, it's doable in November or in December, but the sooner the better.
Okay.
within our purview.
Sounds like we got a lot of homework for our next meeting and things. So again, if you guys can go back to your component areas and again, reach out to see if there's any interested people, then make sure that you get resumes and maybe bring those, you know, or submit them to Cindy and then Cindy can put them in our agenda and stuff, and then we can discuss those. Like she said, at the October meeting, we can discuss which candidates we have and then go from there if we need contracts drawn by December. Any additional questions for Amy before she leaves? All right.
Okay.
Thank you
so
for your
much.
time. All right. So now I think we're going to flip back up to section 8, which is the applications for review. And these are not, they're not present. So our first one is Jacob Bashimi, dentist. So again, graduated from a non-accredited school, dental school, as a certificate program from endodontics and a master's of science in biomaterials. I think it also showed on his application that he didn't answer yes to any of the questions, but he was involved in a domestic dispute altercation, but that was resolved and there was no conviction and all that kind of stuff. That was dismissed in April of 22. So discussion or a motion.
We'll have to schedule the first hearing.
Okay. Yeah, if you guys want to talk to them, then also to let them know. It showed on there that he had an active license in Washington that was issued in 2019, but it also shows that it's expired in 12 of 25. So it doesn't appear that he has an active license. Then, okay.
This is just another one that I'm gonna motion to deny because I don't believe in our statute to give a specialty license based on the statute.
So that's a motion, Ed? Then you're making a motion. Is there a second to it?
The dates on his application don't match the dates of his graduation. I don't know if anybody noticed that, but none of the dates are correct with his transcripts. They're all wrong. And I would think you'd get that right. Personally, I'd like the man to come and speak to us.
If that's a motion from Twyla, I would second that.
That
But
is,
are we
that is a
saying
motion.
Ed's died? My thinking here, just to explain the support of Twyla's motion, he did a 5-year clinical program in endodontics at Boston University, CODA accredited. He's applying via reciprocity though, and I don't know what Washington State's process is as far as board exams. He wasn't required to submit those because he's applying via reciprocity, but I would want to make sure that that is a requirement from Washington State, that he has passed the necessary boards for Indiana licensure. So I think having him here and requesting that he brings all his board scores and everything would be my request. That would be where my vote hinges.
Okay, so there wasn't a second to Ed's, so, but Twyla and Matt have the motion for him to appear. All those in favor, say aye. Anyone opposed? All right.
We're gonna change, we're gonna change our mind next meeting. Especially very few that know.
It's 711.
I mean, it's gonna be fun for him to show up, so.
Okay. All right, our next one is Dr. Carlini. Again, graduate of a non-accredited school in Brazil. Looks like he has a limited student dental license in Kentucky.
My motion on this case would be to approve and grant licensure. He did a 3-year clinical program in prosthodontics at Louisville, passed all the necessary board exams, first attempt. He did fail the Florida law exam once, but that's not of relevance to us. So I think he meets all the requirements for my opinion, and I would motion to grant licensure.
Is there a second? Any further discussion? All those in favor of granting license, say aye. Those that, any nays? Seven, one, one. So it's 7, and then Ed, no, and Robert abstain. My next one is hygienist Brooke. So again, she went to Prairie State and the National Board Dental Hygiene Exam. She has failed 3 times and then finally passed it this past May.
So, in some of our other board information, back on April 1st, 2022, there was somebody who came before us with this same thing. And it was stated in our minutes that the 3-strike rule didn't apply to hygienists. But it's in the minutes from April 1st, 2022. I just wanted to bring that up.
But it does apply.
And I was under the assumption the 3-strike rule was getting amended for hygienists, just like it did for dentists, but apparently that's not true.
I'm bringing it up right now so that I don't just guess out loud and then immediately have to say I'm wrong. I mean, I might have guessed right. It's not a guess, but No, it looks very similar to what you had earlier. It says the board may establish under section 5 of the chapter additional requirements as a prerequisite to taking an exam for any applicant who has failed the exam 2 or more times. So that still stands. I mean, I think that that's actually always been there. So I do think that it hasn't been a bright line for hygienists the same way it has been for dentists. Now it looks like it's been brought up to being even and let you have latitude with both.
Fourth time.
She did pass the CDCA exam on the first attempt. I thought she had a pretty good GPA, but pull it up.
Yeah, her GPA is better than a lot of the foreign trained transcripts that we see. So my opinion as an educator, you know, these are very, very high stakes exams. The NBDHE, it's like a 7-8 hour all day exam. You know, this student could have had accommodations where she had extra time to take the exam. Maybe she, you know, had issues, you know, with comprehension, anxiety. You do not know because her grades aren't terrible. It would be a different story if she had like C's all the way across the board. That would trigger to me the reason why she took it this many times. But, you know, her GPA is not terrible. So, you know, my thought process is maybe she's just not a great test taker. So you know, do we have latitude on this,
Yes.
Leaf?
Okay, Cindy brought up a good point. And so the statute says, board may establish under section 5 of this chapter additional requirements as a prereq for taking the exam for any applicant who has failed the examination 2 or more times. 2513-164 says may not take the examination described in subdivision 3 more than 3 times. So the other one says 2 or more as if there's more than just the number 3, and then it seems like 2513-16 as written forecloses on more than 3. So it's almost like specifically the step between 2 and 3 is where the latitude is. It doesn't seem like that would be likely to be intentional, but gaps in the law are not ours to do anything but to reconcile and fall under them. So yeah, Cindy's right. I admittedly just didn't think that there was going to be another section that stepped on the other section. So that's where we are. It does say that. So what I just read is those both are in there. 2513-164, it's probably no, it's just 4. May not take the examination described in subdivision 3 more than 3 times. Subdivision 3 is must pass an examination administered by an entity approved by the board. So may not take it more than 3 times. So as opposed to 2513-14A, which says may establish additional requirements as a prereq for taking the exam for any applicant who has failed the exam 2 or more times. It didn't completely nullify it, but it did pretty well limit it to right after the second, and once they failed the third, the other one seems to activate. So it does, one limits the other. I can't, that's what it says.
What's the answer to that? Give her some kind of remedial work?
What we've done with others, we've they've had to go get a license in another state and come back and get through reciprocity, right, Cindy? Okay, I was just, because of what we just did here, I was thinking we could do the same thing.
Yeah, that's a pain. And now I can see why people were under different impressions, because two different laws they seem to be doing battle. Yeah, that's frustrating, because I don't know that lines up with what lawmakers intended to have be on the books today, but it is what it is.
Yeah, what if, because I think the intent was to change it for both. So if there was some sort of clerical error along the way, do they have to take this back to session again? Is that what the process would be?
Yeah, they would have to. I mean, when it comes to errors in the law, it's one thing, what's called the scrivener's error is when, if you typo something and I'm like, yeah, but I know what he meant, then you can just treat it as this is too ambiguous for me to just say, well, they clearly meant. But my guess is, I'm guessing on intent, but that's much weaker than what the type of thing that I just described, which is sometimes it's super obvious they just meant to type something else or whatever. This just isn't that. So I don't think that I can advise you to disregard 2513-164. Yeah, it would have to require legislative change.
Is there a motion?
I think we're forced to motion to deny based on the statutes.
Ed, are you making the motion?
Sure. I'll second him.
Matt?
Are we stepping outside of bounds if we let her know there's this backdoor?
If she's listening, she can find that out.
Yeah, you're saying it at a public meeting, so it's not like we're whispering it outside the room, but
So you're on there.
well, a denial letter gives your basis for denial. It'll say why it happened.
Okay. Well, yeah, unfortunately, I will motion for denial and that'll second.
And especially with the other thing is when two laws collide completely, that's also kind of a different situation, but this does actually leave that period between 2 and 3. More than 2 still allows for the third before more than 3 kicks in. So it doesn't completely nullify that other law.
All right. Motion is to deny. All those in favor say aye. And anyone oppose? All right. The next one is Gloria Galindo. Charo, whatever. Again, graduated, non-accredited. And she has a licensed specialty of orthodontics from Mexico.
So I motion to deny based on the fact that none of the degrees are from CODA accredited programs.
All those in favor say aye. Anyone opposed?
Could we add to that denial? Because my reason for denying is there were also no board scores uploaded. We talked about last meeting that they needed to take all the dental hygiene boards and I didn't see any of those either, so. This was a dentist applying for dental hygiene licensure.
No, it's a DDS.
Oh, it was. Okay, I was misunderstanding. Well then, yeah, I'm also against.
All right. So now we have some of the foreign trained. So number 5. Again, the last 3 for hygiene and stuff. So, Annette? Is that how she pronounces it? Again, graduated from non-accredited school in Turkey, and there's no CDCA exam. Did pass the National Board Dental Hygiene exam this past June. Yes.
Those applications were put on for your review to see what we're getting in applications. She does need the CDCA exam, but she would have to have approval from the board to take. So I think that's one of the discussion items that we do have under discussion regarding the foreign trained dentists that want to be hygienists. So if you want to look at this, you want to look at the applications, they were just sort of put on for your review to see. Well, it's up to you whether you want to approve them or not, but I think they're all missing something.
So when I look at the ECE, it comes back as a bachelor's degree on the ECE. And the statute reads that it needs to be a DDS or DMD. Am I correct?
You're talking about the statute itself.
Yeah.
The statute
In-
itself is supposed to be
An
board
equivalent,
trained DDS or DMD,
equivalent to,
equivalent to that. And they have to present with, my understanding, they had to present with a transcript. And it included board exams, the whole gamut had to be presented.
so when we look at the ECE, this says this credential is equivalent in level to at least a bachelor degree in the United States.
Is that what the statute
Most,
says?
most
that was
foreign
passed?
programs are BDS, Bachelor of Dental Science, yeah.
Right, so this would not, when it comes to statute, this is not an equivalent degree.
Do you have the what's the statute say? Verbatim.
The statute, I don't have it in front of me, but
I
it does
know.
say just like the dentist. It says exactly like. the dentist.
Statute, my understanding was written, it's a foreign trained dentist. You have to have, it's a DDS or DMD from a foreign trained. Transcripts in English had to be presented to us with the appropriate boards having been passed.
Right. We talked about this a little bit last time, and my interpretation of that equivalency, because Ed's right, I don't have it in front of me either, but it's a DDS equivalent degree. And my interpretation of that isn't that the curriculums are equivalent, but it's the degree in a foreign country that it takes to be a dentist, which is the BDS degree in most countries. That was the intent of the legislators when they formed the legislation, because if you're taking it as curriculum equivalency, then they would be applying as a dentist, not as a dental hygienist in the United States. It's not DDS equivalent as far as, undergraduate and then 4 years of dental school. And it's equivalency in my opinion, as far as what does it take to be a dentist in your home country? That's the intent of the law.
I can't say I'm necessarily in agreement with that. I'd have to read the exact statute and I cannot find that. But even still, I know in the statute, it says for application, board exams are included.
It says, the statute reads, dental college or university in a foreign country with a degree that is equal to at least a doctorate in Indiana of dental surgery or dental medicine.
So to me, that's reading that as equivalent to a degree from a dental school, doctor of dental surgery or DMD in Indiana.
I believe Nick has some.
Yeah, sorry, I think Cindy addressed it, but because we've been talking about these applications and living them a lot. So I encouraged her to provide a few of these applications that are not complete. So to the point of the hygiene board exams, we're going to have to make them eligible. I told her to bring applications to you before they'd taken boards, because what I don't want to have happen is you to want to deny an application on a previous basis, and then we're asking them to incur a $2,000 cost to take an exam when you're not going to make them eligible. So that doesn't mean they're not willing to take the exam. We've not instructed them or made them eligible. And then I think the second issue that you've all picked up on is the statutory language about DDS, DMD. Well, you just read it. I think the point that Dr. Kolkman mentioned is in many of the countries where people are applying for a bachelor's degree is a terminal degree in dentistry, as it is for physicians. UK degrees, like degrees that are meeting certain educational models, those are terminal degrees in the profession unless you are doing additional training in a specialty. So that's, I think, what the board is reckoning with, but it's probably a lot of, excuse me, the ECE evaluations are going to indicate that it's equivalent to a bachelor's degree because that's the educational model in the country. So those were my two pieces of information. Just want to make sure we weren't counting it against them that they hadn't taken the boards because we're doing that on purpose.
Okay, so I guess what, these last three, so item number 5, 6, and 7, those three, those are not ones that we're gonna decide on. Like Nick said, they don't have the exams. We haven't told them that part. So Cindy put those in there so you could see what she is getting. So this goes to now, we can skip those under applications and we can just jump right to item number F under discussion. This has to do with the foreign train. Cindy is gonna speak here a little bit as well, but she's getting emails from all over the world for applications process and knowing what exactly we need to spell out and things like that. So she needs some direction moving forward with her being bombarded. She said she's got quite a few applications, completed applications that we're going to be reviewing next time. So we'd like to have some discussion here, like these that are applying, do we want these appearances to come before the board, or do we just want their applications that they don't have to physically be here, that we're just going to review their applications? The applicants also need an approval letter to take the exam, and who's going to do that? Who's going to send out that letter? I think Cindy, under that foreign trained dentist file that she just did, there shows some, there's an approval letter from the Florida. So we need to know who's going to be doing that. And does it require to receive board approval? They're also requesting to use, obviously, their Indiana dental board exam instead of taking the hygiene. We've had that discussion that, no, because they're two separate exams, and now the dental board, you don't have to take the perio part and things like that. So I guess that's, and I'll let Cindy have the floor here too, but I think she wants a little bit more for us to bullet point and say this. So she's got a little bit more for the application process, because if we're going to have this many, we're going to be spending an ungodly amount of time here. And there's no sense if they don't even have these in here for us to even move forward. So Cindy, I'm going to let you add. She's the one that's getting my.
Okay, the first thing is the CDCA exam. I have talked to Nick regarding this about maybe, it was his recommendation of possibly having these applicants not submit the exams yet, but bring forward their other parts of their examination, such as their ECE, their transcripts, and everything for you to review to make sure they meet the requirements that you want for a hygienist before we can tell them they can take the exams, or before we give them approval to take the exams. There would be like almost two pathways. You'd have the ones that you're going to review for to be approved to take the exams. And of course, you got the ones that might have already taken the exams, that they can submit those. But to approve their education prior to taking the exams, like they said, it's very expensive to take all these exams. I was looking at the dental hygiene, it's over $1,000. Is that correct?
The 8X clinical and OSCE is $1,150, and then you'll have a facility fee, and then the NBDHE, the written exam, is $600. So you're in for almost $2,000.
So we could have it on there that please submit these documents if you wish to have a review by the board to see if you do meet the educational requirements first. And then you're gonna have the ones that's already taken, which are usually the ones that are in Florida or another state, they're licensed in another state, that have already taken both national boards for dental hygiene and the CDCA exam, or they could submit another clinical exam, whichever. But most of the clinical exams we're seeing is the CDCA for dental hygiene for them. So that's how we're trying to make it clear for them. We just need some answers for this so that we can answer their questions. Because they're sending us things that say, would you please review this to make sure that I meet the requirements? Well, we can't do that. And we require a complete application in order to move forward with the board review. But if this is something that you would do prior to, which means they would still have to, and Nick, tell me if I'm wrong, they would still have to file an application, the application fee, in order to have education reviewed.
Just what material do you want to see?
Yes.
I would hate to make these people eligible if you already know you're not going to issue. It's quite discourteous to allow $2,000 of expense and the aggravation of studying for the exam. If on the basis of a partial application, including the transcript, you already know you're not going to license them. But quite frankly, like I don't want to put my staff through that.
So like, I think that first question we gotta, as a group, decide, are we gonna accept an ECE versus the way it's written? Dental college in a foreign country with a degree that is substantially similar to a DDS or DMD. Okay, so that's number one, because we kind of had trouble with that language last time. They're not come in with a DDS or a DMD similar transcript. So we got to first say, okay, we're going to look at these with their ECE and say that they might be okay. And then if we, based on that, we have them take the test. I mean, that's the gist of all this stuff. But the question is, are we going to say we agree with going past that language and just saying we're going to approve based on the BDS they have, is it equivalent in ECE to be similar to what we want? It's different than what. No.
There's no question it's not equivalent from a level of like standard of education. I'm not arguing that in the slightest. The standard of education for a BDS program is way, way, way lower than a DDS program. So if that's the standard by which we're going from, the quality of education, the curriculum is the same, then without a question, the vote on every BDS candidate is no.
Every single
So
one.
that's the first decision is if we get an ECE back that says Bachelor of Dental Science, which 99.999% are going to say that, the answer would be no. My argument, because this is what I think the intent of the legislators was for these BDS candidates to qualify as dental hygienists. I truly believe that was the intent of the legislation, and the wordsmithing could have been different. But that means if you were a dentist in said country, you got the terminal degree to be a dentist, that's equivalency, and that would qualify you for licensure as a hygienist in Indiana. So that's what I'm going based upon, in which case if we get an ECE back that says Bachelor in Dental Sciences, that's the equivalent dentist program in that foreign country, that home country. So.
That's the question, because it says, is that degree similar to a DDS or DMD? Because that's what the statute says. It must be
Has
similar.
anybody really read these transcripts very closely? Because there's not a whole lot of clinical in them. There's not a lot of preventive dentistry, and there's not a lot of perio. And then I've looked at the GPAs. There's one that was kind of submitted to us that has a GPA of 1.95. There's one that states that they did 20 days in a clinical workshop for perio, 20 days. My dental hygiene students will do 20 days in 2.5 weeks. Almost no radiology. I just worry about the safety, the preparedness. I mean, sure, they take a couple exams. You can get a book and you can study for that NBDHE. That'll get you ready for that exam. You can do that mannequin exam. I just worry about the standard of care.
I agree with you that there's questions on that. My point of view, though, is a dental hygienist has to work for a dentist. There's another licensed professional that has to answer for anything that happens in the dental office. None of these dental hygienists can go out and start a practice and operate it completely independently. There is some degree of oversight from a licensed dentist that takes accountability for what happens in the practice.
The statute reads equivalent to that of a DDS DMD program here, correct? Is that what it says? Equal to-
Determined and approved by the board.
Read it again.
Dental college in a foreign country with a degree that is substantially similar to a doctor of dental surgery or dental medicine as determined and approved by the board.
Okay, substantially similar. If it's, to me, if it was substantially similar by the transcripts, then I got interpretation. But if there's a huge divide, that's not substantially similar, then there's no question. No. That's how I view that. I mean, it says right there, substantially similar to that what we're getting in the United States. And if you've got a program overseas that's not substantially similar, then that's at the discretion of the board. And if you've got a big divide there, that's substantially dissimilar to me, then I'm not going to approve that. If it was really close and everything else and it's really similar, then you would do that. And I think that's where these applications are coming in for us to review, that you may have a disconnect there. You may have some that are very similar and we would approve that, and some are very dissimilar and you would not approve that. And that's what we have to go by. That's how I'm going to look at it.
And when I'm looking at these transcripts, I'm not even looking at like operative or restorative. I am strictly looking at preventive, perio, radiology, things that a hygienist would be doing. That's all I'm looking at. I'm not looking at anything else. And I'm weighing it on, could this person fulfill those roles based upon what I'm seeing in the transcript? And the majority of them, I don't feel great about it.
Well, and majority of them you may not, but you may have some that you do. And I think what Cindy's point is, these applications come in for us to review, and it's up to us to determine where that similarity is. And if we're really close or right there per what the statute reads, what's passed, then, and we say, yes, go for the board, we're pretty confident in that individual. If there's a real big disconnect, we're going to say no to that and save them the $2,000. And that's what you're trying to do. That's what your recommendation is, correct?
Yeah, I mean,
Yeah.
I think I don't have to read the tea leaves. I'm sipping the tea,
Right.
right? Like you
Right.
guys are we're gonna have to provide these applications under the current
Right.
version of the
And
statute for you to
I don't-
review.
What I'm saying is I don't think we're going to make that decision right here based on, yep, they're automatically here. You're going to have to evaluate each application individually based on the transcript and everything else, and if it satisfies that equivalency or near to what we have in the United States.
But is it going?
I have no idea. We don't know that, Bob. We don't know until, well, I know that, but you still may have one or two come through. So that's up to us to make that evaluation. It's not up to us for us today to say, no, we're not going to do that. We have to evaluate the applications as they come through.
Maybe that, but I guess what I'm seeing is the divide we kind of have here on whether 5-year BDS is equivalent to DDS or DDS.
Yeah, but we're not
I
talking
think
about,
what Twyla is saying is that we now, with coming to this is a little different than just someone from the United States applying, is that we really need to pay attention to the transcripts and we need to go course by course and figure out what they've taken, like somebody in Peru or somebody in Brazil or India, they're going to have different curriculums. So like she said, none of these had perio, 20 days in clinic and stuff like that, but it may be something, for a different applicant. So again, like you said, Kevin, we have to go through the transcripts and we're going to have to do it on an individual basis as to how much courses that they've taken.
Yep.
And you're going to get probably somebody that's coming through that has, has done it.
I've done that particularly for this.
Yeah.
I've not seen any of those that would match up to
And I think,
SDMD.
I think the vast majority, I think a high majority will be no,
Right.
but I think there'll be some that creep through. And I think too, there's nothing in there that says coda. Is that written in the statute?
No.
Okay. So I think that you may have, depending on the interpretation of the board, you may have that applicant, you're looking at yeah, he's done she's done perio, he or she's done this, and Twyla says, yeah, we've done this, and a lot of this stuff is very similar to what we do, and we've got a really good grade, and that may be an applicant that we, as a board, might approve.
Well, I didn't even think about CODA when I looked at the transcripts, but when you see a transcript and you have no preventive and you have no perio course, that sends up a red flag
But
in the entire transcript.
I understand that, but you may have that applicant that does have that in the transcript and does have the things that are pretty close to what we do. It may not be CODA, but it may be pretty close to where we are, and that may be a candidate that we may approve. Probably that's going to be a small percentage.
Right.
But that's the task of this board, to evaluate those and determine which ones we feel safe granting that license for our patients out there. And then it's up to us to say no to the other people.
But we're granting them the ability to take a test.
We're granting them the ability to take a test, but we're telling them that their educational requirements are at the level that we would feel pretty confident that if they pass the exam, we would present that license to them. Versus somebody who's just like not even there. We're just saying, it's not going to work for you. And I think that's a very fair thing. And I think that's something we have to do as a board.
So in that vein, I think I like where Kevin's going, but would we see that applicant or hear their application twice? Once to give them permission to take the exam and
Yes.
then another time?
You'd hear them twice. You'd hear the prerequisite things here, from my understanding. Here's what we got going on. We're like, Cindy, no, that's not going to work. Or yes,
See,
it does.
I think I would be on board for one time. Once we give them permission to take the exam, if they pass the exam, they're through. I don't think that burdens them and us a lot more, twice as much if they have to come back again.
I'm not opposed to that. If you say yes, if you pass the boards, then it's going to be a go. I'm not opposed to that.
Okay,
If
okay,
everything
yeah.
is done and they just have
We're,
to pass
when
it.
we evaluate them that first time, we've got to
need to
assume
come
they're
back
going to
to
pass the exam, in which case
Right.
they automatically
And then
go.
they're good to go.
They don't need to come here.
Unless they failed that exam 2 or 3 times.
Well,
and
sure.
That's
then-
it.
then-
But yeah, no, I'm
Right.
fine
Different
with that, Matt, because that
legally
takes
for
away
new
more
grads,
appearances
they
for
need
us.
to
It takes their
yeah.
time down. It's like
Except
boom,
for
and we've already handled that. But you're just pre-screening.
I think I can live with that a whole lot easier just because of what I've seen on a lot of the transcripts.
Well, that's going to be,
We have-
Twyla, that's
we
going to
have
be a
to-
big
we
key.
have
You're
to-
going to have to look at all the transcripts.
I am happy to look at the
I know you are.
transcripts.
I know you are, but I think we have to do that as a board.
Correct. It does.
So the statute originally just had the language that would have required a transcript. The difficulty is if you get an Egyptian transcript translated into English, that perhaps does not tell you everything you need to know about their education, which is why language was inserted in concert with other international application pathways to require not just ECE, or it's a body of different organizations that will verify. They will all come with that. That report is meant to verify equivalency as well. So you can consider that, consider the transcript. I think I've also heard you say you do not need to see them. I think administratively, boy, we would prefer not to have to ask people in Egypt to fly in. And then similarly, you might see individuals, you might see them because the other aspect of this that the statute couldn't really address is just like the complexity of immigration. There are people that are going to be trying to immigrate. They're not going to be able to do the background check. It's a chicken or egg situation. So you may not get a criminal background check until the end of the application, which is anomalous. It's usually the first thing on an application. So you might see them. If you do, that's probably why. I think there are a number of things to work through in the statute that we will simply not know until we continue to get applications. But for today, merely meant to say, are you guys okay with us bringing these applications for you to review so we can provide some courtesy to them, right?
Can I follow? You just brought up something that.
Sure. Yeah.
That you don't want to have them say, go take this test, and we don't have a criminal background on them, though.
Well, I mean, I think you have lots of a traditional applicant would be able to have taken it before then. I mean, the reality of U.S. immigration that they are going to have a social security number and be stateside to do a CBC. That's one of the issues with the bill. I'm happy to let's not get into federal immigration law and policy here today. But like, you're not going to have a license, so don't worry about it, right? They're not going to have a license whether or not they take the exam. The intent of like where and when in the application process they take this exam is just, I don't want to have to be fielding phone calls from people that took the exam that cost $2,000 and 6 months of studying when we knew you weren't going to license them in the first place. But you will always get a CBC.
I mean, my thought process, if we don't have the CBC, which is fine, we already approve people to take the exam in other professions before we even see the CBC. So if they come back with a background, that's on them.
Right.
I
It's
mean,
buyer
they shouldn't have
beware.
applied.
At that point, it doesn't matter
Right.
when you get the CBC, as long as, boy, you get it before you issue them that
Right.
license.
And if it comes back that they've been convicted of murder, felony counts, drug charges, you can still deny that application. But they're the ones that took the chance and trying to get approved through their education to take the exam, so it's on them.
That's on them.
Yeah, I mean, that's true with any applicant that applies now.
Yep.
It's,
Congrats
they,
would take it.
yeah,
They had a criminal background and they spent the money taking it, and then they denied
Yeah.
because of that. That's, they know.
they do have background checks and all the rest.
How many are we going to get of applications? If
Bring your
Yeah.
dinner.
How many do you think we have?
that are fully like,
Thus far, probably over, well over 100, I would say. Well over 100.
Okay, send them. I'll go over
Oh,
them.
it will be that pretty soon.
Okay, so my understanding, so that I'm clear, because I have fog brain today, we're gonna have two pathways. So when Cindy is doing our agenda for next time, we're gonna have two different files. So we're gonna have a file of those foreign trained hygienists that have completed everything. They've taken the test and everything because they may be from Florida and stuff. So we're gonna have those applications and we will be able to review those and say yay or nay, because everything's complete. So that's kind of like a done deal. Then we're gonna have another file of those applicants who have not taken the exam, that have just submitted their applications. Those are the ones that we have to go through line by line and make sure that what they have there, minus their criminal background check, everything there is good, like you said, to say, yes, you can take the exam. If they don't have any, if they've taken no perio, whatever, and we know that there's no way, we're just automatically gonna make the decision, don't bother taking the exam because we're not gonna approve this. Right, right. And Cindy said that that's not a problem with that group of people. If they have everything in their application that we're like, yes, we would approve that, just the exam and you pass it, like Matt, like you said, we could say it's upon approval upon passing the exam. And then if they pass it, then they just issue it and they don't have to come before us again. Is that how everybody feels? Right, well, we're gonna have to do that on everybody
Oh, yeah,
anyhow.
it would be
So if they had something on their criminal background check, like anybody else, it's gonna red flag it and they're gonna have to appear.
Now it is clear the exams that these individuals are taking, that it is the
Hygiene.
ADEX Dental Hygiene Clinical Board, the OSCE, and the NBDHE, not the dental board.
Is that what Florida does?
I think they take the dental board.
Yeah, I don't think they,
take the hygiene. I think that. 'cause
I know
think that's
some
what
of them
these
have,
had,
but
Was the dental board and not the dental hygiene.
Right.
And that's why they were questioning why they can't use the dental board exam and not why they have to do the
Okay.
hygiene one. But we've already stated that's what our preferences are.
so they would submit their application and of course their fee to submit the application. And they would submit their ACE and their transcripts and their whatever else they need for their education. You'll review those to determine whether they're going to meet our requirements through the education first before we approve them to take the exams. Then you're going to have the ones that are complete, but you're still going to have to look at their education, even though they are complete. So we're all on the same path here, right?
Basically bring them all.
Yeah, because right now you're going to have to approve all of them. So, I mean, review all of them. We just needed something to tell these people.
So we bring like sleeping bags and pens.
Yeah.
or-
Can you start sending those like 20 at a time? Yeah, you can start looking at it, but you can't discuss it with anybody. Right. Remember that.
But instead of sending 100, like a
3
week
days
before
our
the,
meeting.
a week before the meeting,
Or even
could you
10.
start
It takes a
sending
while to
like,
get through
you
all
know,
those stuff, I'll be
10
honest
to
with
20
ya.
at a time?
So, yeah.
Cindy doesn't want to buy a sleeping bag either.
You guys know too.
Okay, so, foreign trained dentists that are licensed as a hygienist in Florida, did you say there was a difference? They have
Well,
both
well, some of them have not taken the
Okay, but they're
dental
going to
hygiene.
The other file that we're gonna review everything else.
Right.
Okay.
Right, they go
But,
in.
but if they've just taken the ADEX dental board and they've not taken the ADEX hygiene board, they still have to take the hygiene, ADEX
Right,
hygiene.
so they're
board
gonna
for
go
Indiana.
into the first category.
That's
So
fine.
that anything that they would have to incur an additional cost to take an exam,
Fine.
we're gonna put them in the first pile.
But if you got foreign trained dentists in Florida that's already taken the ADEX hygiene exam, everything, and then they're gonna go in the first pile.
Right.
Are we gonna get their transcripts, the Florida ones that have already?
Yeah.
We'll get, so I mean, we honestly still have to review those the same
Yes.
because Florida's been allowing any of those.
Right.
So I don't really see a difference, honestly, other than that we're gonna make them some of them take a test.
Right.
We're still going to review, we have to review their transcripts.
It's just that they've already taken. it.
Yes.
They've already incurred those costs.
That's still gonna be work.
Right.
We still have to review.
Right.
Right. I just thought it was easier to separate them out in two different files as to the ones that have to do exams and the ones that we already know that are totally complete. Just for my type A personality.
Oh, phew. Okay. Resolved.
Have we totally confused you or are we
No, no,
good?
I get it. I mean, the only residual
Okay.
thing is just like, if we get weird inquiries, we might forward them to Dr. Williamson, right? There's a lot of public inquiries about, like, in our group email inbox. It's hard to convey the number of permutations of inquiries that you can get on something like this, especially because we're early adopters. So we're trying our best.
Excellent. Thank you very much. Yeah.
We will
All right.
start going through those applications, one by one and putting them in SharePoint.
How many you think we need to do the first time? 30?
Oh my God. That's a lot.
We all have to get bogged down. and frustrated.
20. Okay. I think someone real quick. I can read
Yeah. Because some of these, I had a hard time just trying to find the English part of the transcript. I was like scrolling, going, where is there an English word?
Here's
All
the
right.
one question. Can I ask one more
Yes.
question? Before you go. Here's the one question. You're reviewing these transcripts as a dentist, okay? I understand what Twyla's saying about they don't have no perio and stuff. But you've got to remember, how much perio did you have in school? Really?
So, oh my gosh, hardest class the first year. It was crazy.
Okay.
So hard.
So I'm not,
We had a lot of period. Lots.
okay,
Board exam with it.
right.
And it was intense, like.
Okay. I just wanted to be sure. I have no idea what your curriculum, what classes you actually do have to take.
Probably not as much as I just.
Well, I think you're going to have to use,
Yeah, yeah. Actually, knowing.
Technically, dentists don't have as much clinically as hygienists. So we need to do perio surgeries, right?
He did.
I may have observed one, but he had to dig, cut.
ooh,
He had to observe twice, I think.
ooh.
I'd rather did only me.
Rather do a cadaver.
I just wanted to be sure we were all on the same page. That's,
Excellent.
thank you for all the answers. I appreciate it.
Phew. All right, so let's do, what else do we have left here? We have, let's do the continuing ed one with Paige. So she has submitted everything for her organization to provide courses for corona polishing fluoride application for dental assistants. Is there any discussion on what she submitted? Yeah. One thing I noticed, that if we do approve this, that I would recommend for her is that, her certificate of completion, I think needs to have more details. It just said, this certifies, if you guys look that up, it just says it certifies, blah, blah, blah. It has their name and then, it's nothing. So I think she also submitted somebody's certification that came from, IU. So I think on that certification, you want to add the number of hours that they completed in their coursework versus their lab work. There was no date of completion on that certificate. There should be a part, like all the other certificates that you get out of IU, that have like the signature, all that kind of stuff. Hers was just kind of like, oh, you finished the course. So I think that needs to have some more detail.
Did everybody think there was enough hours in these? You thought so? Okay.
And I didn't see that spelled out. That's why I was questioning, like, even on her certificate, she doesn't have like how many actual hours are coursework and, and how many hours were lab work and, was this done? Are they reviewing these YouTube videos, on their own and all that kind of stuff. So I didn't see any of that, I'll be honest with you.
There's nothing, there's nothing like that in her application. As far as ours are on, you're talking about on the certificate of completion.
It's not on the certificate of completion, and I think I would like to see it outlined a little clearer that it's going to be this many, and the only reason why I say that is because I always see it outlined on all of the other CE programs that we approve in the past.
Right. So each class that you're teaching, every category that she had a file on, like fluoride and stuff like that, our previous applications have said 2 hours or they've said 3 hours. Hers don't have that. So is that 15 minutes of her talking?
Suffice for our certificates for the state. Yeah.
Correct. And I'm kind of thinking we need to she just kind of needs to maybe clarify that and make that very clear that this piece is going to be this much and then this much, and then this much for this piece, and then this much for that piece. I think she's kind of got it here, but it's just not
Too
quite,
general.
it's just not quite organized quite the way it should be.
So what do you want her to do
And
though?
we need to see that the hours are correct for Indiana.
Right, that's what I'm saying, because
They-
if she doesn't have them broken down, we don't know if she's met the amount of course hours as compared to the amount of clinical hours.
Right. And so as I
because-
was going through it, I was like, okay, is this enough material to
Right.
equal this many didactic hours? And I couldn't quite piece it all together.
So we don't need, do we need to deny this or just send it back for?
Yeah, can we do that? Cindy, just send it back and say that we need some more definition or more details. I'm not sure, is she on the screen? If she's, I don't think she's on the screen. So again, in the letter that we send to her, just explaining that we need to know each lecture she's giving, how much time is she devoting to each one of those PowerPoint presentations or each one of her files that, she's outlined.
I will draft the letter, send it to you for
Okay.
review, and then you can put it in,
Okay.
just to make sure I have it.
Yeah. So like here, she's got like ethics of infection control. We need to know how much time she's spending on that. She's got, plaque and material alba. We need to know how much time each one of those categories that each one of those lectures, systemic fluoride, topical fluoride, toxicity, each one of those courses that use of handpiece, each one of those, we need to know how much time, because then we have to add all that up to make sure that that goes by what the state requires as far as coursework versus laboratory work. So she has to define those and then, again, define the certificate rather than just you've completed. Thank you. Perfect. All right, so we're going to send that back to her. Again, back under discussion, item number B, compliance fund update was submitted. It looks like in July, there were no expenses. We did have like 1568 in interest. And in the June, I noticed there was something in there, a line item under expenses. There was something for a seat charge of 8075. And then there was also a cyber security baseline at 4777. I don't know what those charges, I don't know what those are, if anybody else. And those aren't consistent, that they weren't every month. Yeah.
Can we have somebody come explain that stuff to us, because we knew that we had expenditures coming out. We agreed to that finally, according to what's the bulletin, state bulletin, blah, 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 blah. We knew there were expenditures.
Yeah,
like that
administrative,
coming out.
yeah, administrative fees.
Yeah, but then whether these are part of that or whether this is some kind of Mickey Mouse new stuff.
I'll talk to you.
Okay.
Yeah. Because expenses for June was a little over 5,000, but that was payments to the compliance officers with that. So, but yeah, if we could have somebody explain what the seat charge and the cybersecurity baseline. It's like seat, SEAT charge, yeah. And cybersecurity baseline. Yeah, yeah, I was like, I don't know what those are. All right, so let's get out of this.
If I get a response back, I'll send the details to everyone.
Okay. Excellent. Okay, Robert needed to talk about something with EFTA, so.
Okay, so, we've been through this before, but I've had a couple of questions. And I want to see if the board, well, I'm on the same page, my thought pattern is the board. So basically, since the FDs are assistants, they are really, we're responsible for them. They, and the code is not responsible for them, the administrative code. Assistants are our responsibility. The question is, uh, so there is a group of pedodontists that are moving into the state from Ohio. The dentist called me and was asking about this, and I hope I've given him the right direction. I feel like I have. In that there aren't really, as I said, statutes or Indiana Administrative Code responsible for assistance per se. We are. Now, so those that were trained in out of state, for them to bring that with them and start practicing, there would be a couple of things. For example, fluoride and coronal polishing, which would be Indiana specific. And there would be, they would probably be bringing their radiology certificate that was from Danby. Okay, and they would have to get an Indiana on that. Okay. Brian, I hope you're up there. Wake up and listen to this. You can explain this to your buddies. Yes, if they were doing nitrous, that would be specific to the state of Indiana. Is there anything else? I can't think of anything else besides those. Pardon? We got it all? Yeah, I think we've got it all. Yeah. And outside of that, their training, is basically kind of the responsibility of the dentist anyway. Anybody have any other comments?
Right, with EFTA, because it's a certification and it's different. So they may be EFTA certified in Ohio, but again, their requirements, they may not be able to place fillings, just like Illinois.
Yeah.
You could be, up until a couple years ago, you could be EFTA, but they weren't allowed to place fillings. So again, coming here to Indiana, that dentist needs to know what they qualified as EFTA in that state that they're coming from, that it's not just because you're EFTA doesn't mean you're EFTA and you place fillings and all that kind of stuff. Because there's
Right.
different requirements, or there's different whatever classifications that go under EFTA per state.
Then those
So
three
again, that would be up to the dentist to
You
figure that
might
out.
double check, Bob, too, because I've had an assistant who was going to go over there, that there's two categories of EFTAs in Ohio. And a higher category, they're allowed to work unsupervised. We don't have that
Yeah.
here in
No,
Indiana.
we're responsible
So
for
you
those
might,
guys.
yeah, they're going
And
to
the
need to know that.
radiology, if they pass the Danby radiology, then it should just be a matter of submitting to the Department of Health
Yeah.
the
For a
Danby,
state-
the
state
Danby
certificate.
exam and their certificate, and then they'll issue them a
Indiana
certificate
radiology.
for Indiana.
Ooh, can I bridge into the next thing?
Okay, wait.
So that doesn't always translate because different states have different requirements.
I think Ohio does. It's pretty similar to here with the radiology.
I had a thought that got away. Maybe
Okay, go ahead. Did you have something?
I did, but it got away.
Oh. I don't see a report in here from the Attorney General and things. Ed, do you have any updates for us? Nothing? Oh, no.
I know what it was.
Okay. All right, Robert?
I know what it was. I'm back. So of course, nothing is going on with this lead apron, lead shield here. We hope to get something going again. I think you guys knew that. Dave Noth was the radiology guy that was going to work on that with the State Department of Health, that was going to work on that before he retired and get this Indiana Administrative Code changed around and all to reflect the ADA's recommendations and all from back, whatever that was, 3 or 4 years ago. Of course, he retired. That didn't get done. And then there've been some changes there. So the radiology division isn't just hooked up with the State Department of Health. Now it's in halves with Homeland Security somehow. So there are new heads there, and there are 2 groups of new heads. I got this information from Dr. Chalwa with the State Department of Health Dental Division. So anyway, we're going to try to approach whichever two would be appropriate to talk about, going back and working on that Indiana Administrative Code 410 so that it reflects what the ADA had recommended 3 or 4 years ago. So anyway, it's lost for now.
All right, I believe Rick is going to give us a report on the Attorney General.
Yeah,
Yes?
you should have that in front of you. Hopefully you got that from us. Okay, I can do a verbal report if that's okay. You guys are used to seeing it. We're at 8.9 on the investigative files. That's 78 total investigative files. Average age for litigation files is 2.7 months, and then that's 3 open files. I know you asked for some additional data. Ran that on those 78 investigative files. So county-wise, there's 24 different counties. That's running from complainant's address on the consumer complaint form. The top 25% of those complaints from the 78 is Marion. 13% is Lake, and then 8% is St. Joseph. I thought just those top numbers were relevant. I don't think you want me to go through all the data there, but then running the primary practice codes where you were interested on, what is the category of consumer complaints that we're receiving. 93% is licensing misconduct. And then we can kind of run an additional code in that 93%. We have additional categories, and out of that 93, 54% is professional incompetence, and 32% is professional malpractice, and then 5% is falsifying records. So hopefully that gives you what you were requesting at the last board meetings, just some of the additional data that I'm happy to provide, not necessarily at every meeting, but happy to give you that like quarterly or, twice a year.
Okay. Quarterly would be nice.
Okay.
I think we have to make sure Lake County stays number 2. I'm glad to see Porter County wasn't number 3. Usually it's Lake County, Porter County. It's usually Marion, Lake Porter. So, Matt.
So we had a case earlier today. Peter Andrews, looking for his real name, Khalid Hashim. The Canadian guy. It was in process for 2 years, and within about 10 seconds of a Google search, I identified like several very concerning allegations that endangered public health. So what would it take? Like, why did that take so long? Where's the crossover to like, okay, we are going to escalate this immediately to a immediate suspension versus we'll drag this out 2 years before we do anything about it?
Sure. So I was not the deputy on that
Yeah,
case,
no, I
right?
understand.
So I
Yeah.
can't speak to those specific analysis, but I can speak to, we had a new section chief, Heather, about 18 months ago. Kara is our new section chief now, but we have now a very thorough summary suspension review process, a standard operating procedure on how do we evaluate those cases, not only the investigator, but the DAG. And we're looking at those very closely as a team. It's mainly the investigator's file, but as the attorney, I am quarterbacking, that investigation throughout the entire process. So I can say, again, I can't speak to over 2 years ago and initially, but for sure, we are always concerned for the public health and safety. And we've definitely evaluated our processes and procedures as a team and how we do that. And so I heard the board's concerns on that case today, and I hope I take that very seriously as lead DAG of this team.
And then piggybacking on to Matt's, Jen, recently we have another case before us that a few years ago, we've actually revoked this dentist license, and we have recently found out that he's practicing. And again, I was kind of, a little shocked seeing that he wasn't on our agenda. Again, this is a, endangerment to the public, we've revoked his license and he's practicing. So again, this is not something we want to see 2 years from now. This person has a number of things, offenses against him. He served jail time for Medicaid fraud. And again, and so now his license is revoked. So why was he not on our radar today?
I want to be very careful, and I'm sure advisory will say this as well. Speaking to anything that's an active investigation could be confidential. I don't know what case you're referring to
That's
specifically,
why I
but
didn't mention
I
names.
definitely want to be very careful as far
Right.
as the confidentiality statutorily of any sort of active investigation that might be ongoing. But as the board is well aware, we can't investigate unless we receive a consumer complaint. So if there is something that is out there that you don't feel like we're aware of, the board, IPLA, can always file a complaint with us. But again, I want to be very careful of not speaking on any sort of complaint that could be actively under investigation and that could impede future litigation.
Mhm.
I don't know anything about this at all, but I just wanted to bring to your attention that if it's a revoked licensee, that's not somebody they can bring an emergency proceeding on. It's not a summary suspension proceeding. So there are steps that they can take. If they were going to try to take immediate action, it would be a civil action and not a board action. So there's that. So I just wanted to throw that out there. You would not see a summary, if that's correct, that it's a revoked licensee, that's not, you could only summarily suspend a license. and once
Yeah.
it's revoked.
So not only that, so I filed a personal consumer complaint, and I can say that an active investigation is going on, but a little bit more on this case. Not only was his license revoked, but a cease and desist letter was after the revocation also issued by the board. So I don't think
At
it
that
will
point,
ever
it
cross
becomes-
our,
Yeah, at that point, the board is out of
Yeah.
plays and it becomes a contempt of court issue. So
Yeah.
Okay.
that's why you would not see that on your
wouldn't see it.
agenda.
Okay.
So
I don't think we'll
I
ever
don't confirm anything about whether that has happened here, but
So
it
we
makes,
won't see anything on that case then, correct? They won't
no,
find anything
but if
else?
but if it was something that became a public action, they would not have confidentiality that would prevent them from telling you about it at that point. But if it hasn't, then they have to keep everything very close to the vest until something becomes a public action. Once they have sued somebody or filed something in court against them, well, that's not a secret anymore. So
yeah. So
That answers my
I don't
questions.
have anything else to share on that, but I think they are in the process of dealing with it. So.
Okay. Perfect. Thank you.
Yeah, no problem. Thank you.
Any other questions for her? Thank you very much.
Thank you.
Is there any old or new business? Is there a motion to adjourn? All right. Meeting's adjourned. Thank you.